1 o'clock, and I will go ahead and call this meeting to order. I note that Commissioner Wilkins and Commissioner Weatherall are here. I'm here as well, and so that is a quorum. 2.0 is additions and revisions to the agenda. Do we have any additions or revisions, Commissioners?
I do not.
Okay. Then we'll go into correspondence and public comment. I'll start with public comment. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to be recognized by the chair, give your name and address, and limit comments to 3 minutes. I see we have quite a few people on here. I'm assuming some folks are here for the public hearing, which will start at 1:05. So those public comments need to be part of that record. But for anything else on the agenda or anything not on the agenda, are there any public comments? If you dialed in with your phone, you just need to press *6 to unmute yourself. And if you signed in through your computer on the Zoom platform, then the little mute button is in the lower left-hand side of the screen, and you just click that to unmute yourself. And I'd like to also just remind folks who are new to our meetings that we're pretty informal around here. So if something pops up later and you want to just comment, you know, we're pretty informal. So just interrupt and get my attention, and staff will be looking as well to see if people look like they're wanting to comment. So it doesn't look like we have any for now, and so I'll move on to correspondence.
Hold on just a minute. I did have something. I didn't. I was waiting for you to quit talking. So this is
okay.
This is Steve Schaefer, 211 West Penoyer, Condon, Oregon. My comment has more to do with the agenda. The agenda just seems to be very, very packed with an awful lot of items that normally are handled after the first of the year. My 6 years as the Gilliam County judge, never saw anything like this during my time. About 25 years of looking back on agendas, never saw anything like this before. The perception that I have is that we've got a new county court coming in. It appears that we're trying to maybe run things through. This is not an accusation. This is definitely a perception of what looks like is going on. I know what the circumstances are. I still feel that there's a lot of things here that need a lot more discussion than just being put into the consent agenda. I think the public has every right to know who these individuals are, why it was that many of these appointments have been selected, and with zero discussion about any of them. I'm going to have to say that the consent agenda being full with roughly 2/3 of items that really should be part of a discussion process just doesn't look very good, folks. Also, I had one more thing that I wanted to comment on, and that's in regards to the rural renewable energy zone, development zone. I think you guys really need to take a hard look at that. That is something that develops an awful lot of revenue that comes into the county during the construction phase, shortly after the construction phase, and it's something that sets up a new tax base. If somebody had told us that we're going to have a business setting in here that's valued at $250 million 5 years down the road, we'd all be jumping up and down wanting that business here. So I would prefer, I guess my point with that is take a hard look at that. Again, there's a whole lot of grocery stores, restaurants, healthcare centers, people who rent houses, people who rent space for travel trailers. That's revenue that they would love to have. Thank you.
Thanks, Steve. Any other public comments while we're on that? Again, when we get to the actual hearing itself, if folks are wanting to speak about item 5.0, that'll actually happen here in about a minute. and so any comments about that planning piece actually need to be part of that that proceeding. But anything else that's otherwise on the agenda or not on the agenda that somebody would like to comment on?
Judge Farr, this is Pat Shannon from Arlington.
Yeah, go ahead, Pat.
Yeah, I just wanted to comment on the giving some more consideration to the red zone exemption, not necessarily just because of this project, but also because of being receptive to these projects going down the road and incentivizing those types of projects and looking like we want to get them here. So I think it's bigger than just this one project. It's also a consideration of how we look to the industry and their willingness to come to Gilliam County to bring these type of businesses in. And then the other comment I'd make, and we could talk later when you get to it, but the strategic plan to me is missing one of the most important parts of it, and that's what we want our county to look like in 5-10 years down the road, and the plan on how to get there. And so I'd like to see us slow that down and really give some more consideration to what that plan should look like. Thanks.
Okay.
Hello?
Anybody else? Go ahead.
This is Guy Weedman, and I was just calling about for the rock pit and the solar there at our place. Is it better that I talk to you when you get to that part?
That would be great, yeah, so we can make sure that's part of the official record on the planning action.
Okay.
So we'll be to that momentarily. If you'll just stick with us for a minute, we'll be to that shortly. Any other public comments while we're on this section?
Hello. Can you hear me? This is Tim Holtz. I was calling about the red zone determination. Does he want comments on that later when you get to that, or now?
We can do either. It may make sense to do it as part of that conversation so that it's in context with that. We're happy to take comments as we're doing that if you can stay with us. If you have to jump off before then, though, and you want to provide it, that's fine, too.
Okay, thank you.
Okay. Anybody else?
This is Brian Walsh. I just think that it wasn't clear whether there was going to be a public comment period later on in the agenda, so that's I think what my concern other folks had. But thank you.
Yeah, and I think you might have missed just the first minute or so, but I always like to remind folks that we're real informal here, and so the commissioners are always welcoming to people who want to interrupt and interject as we're having these conversations and asking questions. So we definitely encourage that participation either upfront or when we actually get to that part of the agenda is great as well. We would welcome that. So it just kind of depends on everyone else's timing and when they need to hop off. But
okay.
Any other public comments?
Question.
Oh, go ahead, Brian.
Oh, yeah. Oh, I'm sorry to cut you off there. I was just curious. It's been a while and the agenda is pretty full. Like, how long do you anticipate the hearing there to go today?
It depends on how long our public hearing lasts, really. That'll be the big driver, I think, of everything on here. So that'll depend on how many people want to comment on that. So my best guess is probably by, I don't know, 2:30, we would be to the red zone designation, if not before, depending again on how many people want to testify during the planning hearing.
Great. I just didn't know if you had a hard stop.
No, we're here until we're through with the agenda.
Okay, great. Thanks, Liz.
Okay. Any other public comments, folks? Okay. So with that, I think we can do the consent agenda next, and then we'll go right into planning. So, commissioners, I did to Steve's point on there are a lot of appointments for commissions and boards that we have. The reason for that is that most of these terms expire January 1. And with my maternity leave, that means we would have boards and commissions that, especially like our planning commission, Michelle would lose her quorum basically on planning and other things come January 1 if we don't make appointments prior to the end of the year. So that's why those are all on there. I'll also note that in cases where there's multiple people vying for a limited amount, we usually put those on for discussion, and all of these, we had either the right amount of people for the number of vacancies or even fewer people than the number of vacancies we actually have. So, but again, any of these are things that if you guys want to pull from the consent agenda and think deserve further discussion, obviously that is how we handle the consent agenda. So any questions about that? The only other thing I wanted to flag as well is we did get a lot of citizens who were interested in the Columbia Ridge Landfill Citizens Advisory Committee. And so that normally we would have 6 or 7 people on it. You'll see the list is far greater. I opted to just put every name on there because we had so much. But if that was one that you wanted to pull and discuss further, I just wanted to flag that for you. It does not appear that statute limits the number of people who can serve on that. So I didn't want to turn people away if they have an active interest in being involved, because I think that's important. So anyway, consent agenda.
Well, these were all people who volunteered to serve on these committees. And as you said, either we have completed the required number of appointees, or we have exceeded in the cases where we can. So I'm not sure what kind of discussion we need to have on the appointees who are willing to serve our county in these capacities. I'm grateful to those who have stepped up and have offered their services.
Agreed. So do we have questions or a motion on the consent agenda?
I move we
or
approve
anything
the
you want to
consent agenda.
I have a question. Should I second?
Go ahead.
I was just wondering if we'd had any feedback from the committees themselves. I mean, did they weigh in at all about the people that were interested, or are they just taking whoever, any and all that are interested?
So if the committee had feedback, it was noted in the briefing. So like the library board asked that we appoint Dorothy Schott because they would like to have an extra, they had more room and they wanted to have an extra. Some of them, you know, like the compensation committee, there wasn't really a committee to ask because those members turn over every year. And so 2 of them had already resigned, so there wasn't a people to ask. So it just kind of depended on the committee.
Do we reach out to people that are currently serving on the committee, even if their term is expiring, to ask if they would like to continue?
Yeah, so the process we engaged with is we sent letters to each of the people who was currently serving to let them know their term was up and when it was effectively up, and ask them to let us know if they were interested in continuing to serve. And then we also, regardless of whether they expressed an interest or not, we advertised all of the vacancies. So if there was additional interest out there, that allowed the public to know that there were vacancies and that they could throw their name in the hat. So the exceptions to that are like the Lower John Day Area Commission on Transportation, because those are city seats that typically, historically, we've appointed city representatives to.
Okay, thank you. Do we need a second still?
Yes.
I think we still need a second unless you seconded. I don't know.
now.
Did you?
I will now.
Okay. Okay, so it's been moved and seconded that we approve the consent agenda, which consists of consider approval of October 18th regular meeting minutes, consider approval of October 18th work session minutes, consider approval of October bills pending review, consider approval of CARES Act subgrant agreement with NORCOR, consider approval of intergovernmental agreement number 165-210012-20 with Oregon Secretary of State for Electronic Records Management Services. Consider approval of subscription services contract with Chaves Consulting Incorporated for Electronic Records Management Services. Consider appointment of Dorothy Schott to the Gilliam County Library Board effective November 18th, 2020 through June 30th, 2024. Consider appointment of Gary Betancourt, Marta Michelo, and Leah Watkins to the Gilliam County Fair Board effective January 1, 2021 through December 31st, 2024. Consider appointment of Nicole Schott and Eric Harrison to the Gilliam County Compensation Committee effective January 1, 2021 through December 31st, 2024. Consider appointment of Jeff Schott and Derek Heiser to the Gilliam County Planning Commission effective January 1, 2021 through December 31st, 2024. Consider appointment of Gibb Wilkins and Bill Rosenbaum to the Lower John Day Area Commission on Transportation effective January 1, 2021 through December 31st, 2022. Consider appointment of Mary Dyer and Carrie, remind me how you say Carrie's last name.
Cowan.
To the Gilliam County Cultural Trust Coalition effective January 1st, 2021 through December 31st, 2023. Consider appointment of Brad Anderson to the Gilliam County Budget Committee effective January 1, 2021 through December 31st, 2022. Consider appointment of Derek Heiser to the Gilliam County Budget Committee effective January 1, 2021 through December 31st, 2023. Consider appointment of Donald Jameson to the NORCOR Budget Committee effective January 1, 2021 through December 31st, 2023. Consider appointments to Gilliam County Coordinated Care Organization Local Community Advisory Council. Consider appointments to Columbia Ridge Landfill Citizens Advisory Committee effective January 1, 2021 through December 31st, 2022. Consider appointment of Nathan Hammer as Gilliam County Budget Officer. Designate voting precincts Arlington number 1, East Condon number 6, West Condon number 7. Designate county roads outside of incorporated areas of Arlington, Condon, and Lonerock as Road District number 1. Designate Gilliam County depositories, Bank of Eastern Oregon, U.S. Bank, and LGIP. Designate records, newspapers of record, Times Journal, and Eastern Oregonian. And consider appointment of Ron McDermott, Robin Ordway, and Kathy Stinnett as Justice Court Pro Tem. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay. We will, let me just get on to the next thing. We're running just a smidge behind on our public hearing. Before we jumped in, though, I missed something under correspondence. I just wanted to note for the record that we had received an email from Lori Anderson with some questions about finding COVID-related statistics for the county, and then also asking the commission as a whole to advocate for keeping businesses open. This is in light of the governor's announcement of the 2-week freeze that is starting today. So I just wanted to note that for the record. For folks who want to read the full thing, that will be available on the county's website. All right, we'll go into 5.0, public hearing for the purpose of considering a comprehensive plan amendment. This is the time and place set for a public hearing on combined application CPA 2020-0002 and CUP 2020-0002, proposed text amendments to the Gilliam County Comprehensive Plan to add aggregate resource site number 1002 Weedman to mineral and aggregate inventory as a significant aggregate site, as well as a conditional use permit for mining, crushing, stockpiling of aggregate, and a batch plant. If approved, the land use decision would be implemented by the adoption of Ordinance number 2020-03. A form of that ordinance has been provided in the application materials, but the county court is in no way obligated to adopt the ordinance. The hearing is now called to order. The public hearing will be conducted as follows. First, staff will give their report and answer any questions from the county court. Following the staff report, we will hear the applicant. I will then open the hearing to public testimony. After the opportunity for public testimony, the applicant will have an opportunity for rebuttal. The county court may then ask any additional questions for staff. The county court will then decide whether to close the hearing and deliberate the matter. As the hearing proceedings is being done via Zoom, I will ask if individuals wish to give testimony. When you testify, please state your name and address for the record. Please keep your testimony concise and relevant to the issues before us this afternoon. It is encouraged that you simply agree with the point made by a prior speaker instead of remaking the same point. The criteria applicable to the proposal are listed in the staff report. These are the criteria the county court must use to make its decision. Failure to raise an issue with sufficient specificity to afford the county court and all parties an opportunity to respond to that issue may preclude an appeal to the Land Use Board of Appeals based on that issue and may preclude an action in circuit court. Failure of the applicant to raise constitutional or other issues relating to conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. At this time, I would ask the members of the county court to disclose any ex parte contacts, bias, or conflicts of interest a member may have pertaining to the proposal before us today. Please indicate the nature and extent of the ex parte contacts, biases, or conflicts of interest, and indicate whether you intend to participate in or abstain from the hearing. Are there any conflicts that the commissioners need to disclose?
No.
I do not have one.
None here either, and no ex parte contacts as well, correct?
Correct.
Okay, same with me. Does any member of the audience wish to challenge the ability of any member of the county court to hear this matter? And again, if you want to take yourself off of mute, you just dial *6. If you signed on via your computer, then you can unmute yourself in the lower left-hand corner of the Zoom screen. So I'll give people just a second, and I'll do this throughout the meeting just because I know it can be challenging on Zoom to get yourself unmuted in time. So we'll just pause there for a second and see, again, if any member of the audience wishes to challenge the ability of any member of the county court to hear the matter. I do not see anything. So we will go into staff report and questions. Staff will now present the staff report and any correspondence on this matter other than those items already included in the record. And I'll turn it over to Michelle Colby, our planning director.
Good afternoon. Can everyone hear me?
Yes.
Great. Good afternoon, Judge Farrar and Commissioners Wilkins and Weatherall. The county court has received a copy of the staff report, attachments, and the draft ordinance and exhibits a week ago. I'm going to presume the court members have had time to review the materials, and therefore I will do my best to provide a summary today. Also, all the materials were posted on the Gilliam County website last week as well. All the materials as they were provided in the packet are of record, and so I don't have to review every single point of the staff report unless, as I'm summarizing, there's questions that we need to review. The staff report addresses 2 approvals. They are requested concurrently as one cannot occur without the other. Approvals will allow an aggregate site to be added to the Gilliam County Comprehensive Plan, and the second approval is to allow a conditional use permit for an aggregate mining site on exclusive farm use zoned land with the proposed conditions of approval. The aggregate site is to be located off a baseline road, a county road, and the proposed site is to be approximately 30 acres. The Gilliam County Zoning and Land Development Ordinance criteria and for the aggregate site is detailed in the staff report that was provided to the county court in advance of the public hearing and is found as Exhibit A to the draft Gilliam County Ordinance number 2020-03. Applicable land use standards included items from Article 4, exclusive farm use, allowable conditional uses, Article 7, conditional use standards for mining, quarrying, and other extraction activities, Article 8, standards for mining operations, and Article 10 and 11, process for amendments and approval criteria. In addition to the Gilliam County Land Use Zoning Ordinance, applicable standards within the Oregon Administrative Rules, Section 660-023-0180, titled Mineral and Aggregate Resources Standards were also cited within the staff report to determine that the site is qualifying as a local, small, significant aggregate resource. And what that means is the site can mine no more than 500,000 tons of aggregate material for the life of the aggregate site. It is important to note that the land upon which the proposed aggregate quarry is to be located is not high-value farmland. This is a new site within Gilliam County, and all sites of significance are to be on the Gilliam County inventory list of significant aggregate sites, which is contained within the Gilliam County Comprehensive Plan. Therefore, the request for a comprehensive plan amendment, as illustrated as Exhibit B to the draft Gilliam County Ordinance 2020-03, the Planning Commission held a public hearing on October 13th and is recommending to the county court to approve the amendments to the comprehensive plan and the proposed, which is proposed under land use file CPA 2020-0002, and to approve the conditional use permit land use file CUP 2020-0002 with conditions of approval as proposed by staff. An aggregate site has potential to create nuisances. However, as documented in the staff report, staff is of the opinion that nuisances such as dust, noise, vibration, glare, and odor can be minimized through the conditions of approval. The site is not next to any rural residentially zoned land. However, there are residents in the area as allowed in the farm use zone. However, these residents are outside of the standard of 150 feet from the site, which is considered the impact area. All of the immediate land surrounding the proposed aggregate site and the tax lot the site is located within is all zoned exclusive farm use land. There are no known conflicts with agricultural practices in the area. The intent desired use of the potential aggregate product is for commercial use, specifically to be able to offer aggregate to any energy development, wind and or solar in the area. I'm going to pause for a moment. Are there any questions at this time? And everyone still hears me? Okay, yes. I will continue. As with most conditional use permits, there are conditions of approval attached. Part of the process involves approving the proposed conditions of approval. I will review the conditions of approval as staff is proposing the following conditions, and these conditions are pretty standard for any aggregate site. Condition number 1, compliance with applicable laws and permits. The approved use is subject to comply with all applicable state and federal laws and permits. Without limiting the foregoing, this condition requires a valid DOGAMI permit, which stands for Department of Geology and Mineral Industries, mining permits, and if necessary, an approved Department of Environmental Quality permit showing conformance with air quality and emission standards prior to any earth disturbing activities. Copies of all DOGAMI permits and annual production reports must be provided to the county. Condition number 2, setback. All mining activities must be set back of at least 50 feet from baseline road, which is a county road, right away, and all other property lines. Berms and other forms of screening and access haul roads may be located within the setback area. A revised site plan will be submitted to the Gilliam County Planning Department demonstrating compliance with setbacks and other conditions of approval. Condition number 3, sanitation. Portable sanitation units must be provided by a licensed supplier during any period of active mining operations. Condition number 4, solid waste. Solid waste must be disposed of at a permitted and licensed facility. Condition number 5, access and condition of county and state roadways. Access to the site is from baseline road, which is a county road. If a new access is desired, the landowner will be required to obtain a road department approval. The landowner is responsible for any damage to and or state roadways demonstrated to have resulted from the use of vehicles to and from the site. The Gilliam County Roadmaster may require a road use agreement prior to any earth disturbing activities at the site. A road use agreement is to protect the county roads from damage as a result of the heavy activity at the site. If peak use exceeds 50 trips, which was proposed in the application process, which includes inbound and outbound as separate trips per day, the county may require additional transportation mitigation. Condition number 6, site inspection during construction and operation. The landowner shall allow site inspection by the Gilliam County Planning Director or designee to assure compliance with permits. Condition number 7, operations. Work hours are limited to 5 a.m. to 11 p.m., Monday through Saturday, excluding federal holidays. And I will just put a little disclaimer here, right? This condition was debated at the Planning Commission hearing, as it was originally proposed as limiting the hours of operation to 7 a.m. to 7 p.m. And there was a request or a plea made to the Planning Commission to extend the hours to 5 a.m. to 11 p.m. to allow a dual or split shift during heavy activity mining, blasting, crushing, so that any operator could get in and get out expeditiously and maximize production in a short amount of time. And so by a vote of 3-1, this condition at the conclusion of the planning and hearing was changed to the hours of operation of 5 a.m. to 11 a.m. Condition number 8, material for batch plant. The material processed at the batch plant must originate from the site. Importation of material for processing is not permitted. Number 9, permit boundary. Operations including but not limited to aggregate extraction, crushing, screening, stockpiling, equipment storage, etc. shall only occur within the permit boundary, which is the footprint shown on the approved and attached site plan on file with the Gilliam County. Any changes to the permit boundary will require modification to this conditional use permit. And I would just like to add a little statement. This is very important, especially when it comes to the state agency of Dogami. They look at what the county has approved and they will match that. Both boundaries, both applications to each entity must match. And we have had where there has been a discrepancy and then we have to go through an amendment process. Condition number 10, screening. Landowner must construct a permanent berm no less than 6 feet above the natural grade along the frontage of baseline road to screen all mining operations. Rock crushers must be screened behind a berm and or a cut bank on 3 sides of no less than 15 feet in height in the aggregated measured from the grade at which the rock crusher is located. Berms may be constructed over time as overburden is removed from the mining site, but must be completed no later than 1 year after the commencement of active mining operations. Condition number 11, entry barrier. An effective barrier or gate, for example, a cable gate, shall be placed across the access points into or out of the aggregate site to prevent unauthorized access to the quarry. Condition number 12, dust. A water truck or other dust suppression measures acceptable to the county must be employed during any earth disturbing activities and active mining operations to minimize dust trespass onto roadways and adjacent properties. Condition number 13, noxious vegetation. The landowner must control noxious vegetation within the permit boundary at all times. Condition number 4, removal of all mining related equipment. All surface mining equipment, machinery, vehicles, buildings, and related structures accessory to the mine, the mineral and aggregate activity shall be removed from the site within 30 days of completion of all the mining, processing, and reclamation. Condition number 15, reclamation. Sorry about that. I didn't know if you heard that phone ringing. I just put it on mute. Back to condition number 15, reclamation. Active mining shall only occur within one of the 7 designated mining areas shown on the approved site plan at the time, except the active mining operations may overlap between 2 mining areas for no greater than 6 consecutive months to allow for development of the new mining area and wind up reclamation of the prior mining areas. Reclamation of the Exhibit A, County Court Ordinance 2020-03. Mining area excluding any required plant growth must occur within 6 months after commencing mining operations in a subsequent mining area. All reclamation must be performed in accordance with the Dogami, which is our state agency partner approved reclamation plan within 1 year after the end of the mining activities on the site. Condition number 16, permit timeline. this conditional use permit is valid indefinitely after development of the mine has been completed, provided the landowner maintains a valid dogami permit. If a dogami permit has not been maintained for any period of 2 consecutive years, the landowner must reapply for a conditional use permit. Condition number 17, aggregate limit. Again, as I stated in the summary, and you would find in the staff report, this aggregate site is not to produce more than 500,000 tons of aggregate material for the life of the site. The county is to be supplied with a copy of the production reports to Dogami. Condition number 18. Condition number 18 was a new condition that came out of the Planning Commission meeting when they approved extended hours of operation. And so condition number 18 is lighting. Any outdoor lighting shall be shielded to illuminate downward. Any outdoor light source, bulb, or element shall not be visible at or beyond the property line. Any outdoor lighting shall not be visible at or on Baseline Road, a county road. And then condition number 19, which was suggested from Dogami representative that reviewed the staff report, post-mining uses. Post-mining uses of the subject property are limited to those uses permitted in the applicable zone, subject to all required permits and approvals. And then in summary, compliance with the conditions of approval shall be the sole responsibility of the landowner. The landowner shall be responsible for assuring that landowner, landowner's leasee, and the respective employees, contractors, subcontractors, and invitees involved in the development and operation of the quarry are in compliance with the conditions of this permit. This authorization does not allow for any change in use or further development of the site. Those are the conditions as proposed. The county court can choose to amend them if during the course of public testimony, if there's comments or if there are statements that regarding the conditions, it is within the authority of the county court that they can amend these proposed conditions of approval. But I just stated what they are being proposed by staff at this moment in time. Are there any questions of the county court regarding the proposed conditions of approval at this time?
Commissioners,
Okay.
any questions?
I don't have any at this time.
I don't have any.
Okay, well, thank you. I am done right now with the summary of the staff report. And I just want to reiterate for the record that the entire staff report, all of the attachments to the staff report, the draft ordinance, and the exhibits to the ordinance have been entered into the formal record.
Great. Okay, so we'll move on to the applicant presentation. Does the applicant or the applicant's representative wish to make a presentation? And I see Weedmans are on. So this would be your time.
Can you hear me, this guy?
Yep, go ahead.
Okay, I was just, as a landowner there, I just making a short comment that, you know, it's benefit being for this, if this solar farm happens in the future projects for wind or whatever, it'd be close and save some money getting things done. And we have 7-8 miles of roads that we have to keep graveled, and it would be a benefit to us, plus income to our family. Our family is pretty large with 6 families, and everything that we can get keep us all here is what we keep trying to do. So that's all I had to say. Is I would like it to go through, if possible, to help us out and make things work easier for the projects. That's it. Thank you.
Great. Commissioners, do you have any questions for Mr. Weedman?
I do not.
I don't. Thank you.
Okay, so we'll move on to public testimony. At this time, we will receive public testimony. Proponents of the application shall speak first. Opponents of the application shall speak second. And neutral testimony shall proceed third. And because we're on Zoom and sort of recognize that it's hard to unmute, I'm going to give lots of sort of dead space in between so that folks have plenty of opportunity, so that we make sure that your comments are part of the record. So we'll start with, is there anyone who wishes to speak in favor of the application? If so, again, if you dialed in, *6 will unmute you. If you came in via your computer, then you can unmute yourself in the lower left-hand corner. So again, anybody wishing to speak in favor of the application, and we'll give just a second to see if anybody wants to unmute.
Yes, I'm Mike Osborne with D. Atlee Crushing. We're part of the application. And I just wanted to say that we hope you guys accept this. And we try to be a good neighbor. And we believe that putting the quarry up here reduces a lot of traffic on the roads where the rock could come from, and kind of puts us in the middle or right next to the projects that could come up. We would, you know, we always pay attention to mitigating sound. Eventually, after the first crush, we will have room to put the crusher down into the quarry itself, and we will be very hidden and bunkered in. We plan to stockpile next to the road, which will take away the nuisance of seeing anything there, and we will crush on an as-is basis. And we typically, with 2 shifts, do about 100,000 tons a month. So you, with 2 shifts, we'll be in and out before people can even know we're there. So we're hoping that you accept this, and sorry, I'm losing my voice. We're hoping you accept this, and we appreciate your guys' time to listen to us. Thank you.
Great. And Mike, just for the record, could you also just state your address as well so that we can get that captured for the record?
4307 Snake River Avenue, Lewiston, Idaho.
Great. Anybody else who would like to speak in favor of the application? Again, we'll give you a second. It's *6 to unmute your phone, lower left-hand side of the Zoom platform if you came in on your computer. Anybody? Give it just a minute. I know it can be hard when you're trying to unmute in a hurry. Just *6 on your phone or lower left-hand corner and click the unmute button if you're on the Zoom platform.
Well, Liz, I'll chime in just with a comment in favor of the rock pit. You know, Mike kind of covered some of the benefits of the rock pit for me, but I would like just to echo his comments on, you know, having a rock pit that's in close proximity to the projects that we're building, you know, does greatly reduce wear and tear on the county roads and state roads, reduces pollution and emissions for those trucks going back and forth. But yeah, also noise, nuisance, and so anytime we can get those rock pits and water sources closest to the projects that we're building are of great benefit. It also lowers the cost of the construction and the project, so all around a benefit. So we're in favor.
Great. Brian, can you also, just for the record, state your full name and address so that Teresa can get that in?
Yeah, Brian Walsh, Avangrid Renewables, 1125 Northwest Cooch Street, Portland, Oregon, 97209.
Great, thank you. Anybody else who would like to speak in favor of the application? Again, that's *6 to unmute, lower left-hand side if you came in through your computer.
This is Steve Schaefer. I want to speak in favor of it. I really don't have anything to add, anything other than what Mr. Weedman and Mr. Walsh have already stated.
Okay, Steve, could you also, for the record, give your address?
For the record, yes. Steve Schaefer, 211 West Penoyer, Condon, Oregon, 97823.
Great, thank you. Anybody else who wishes to speak in favor? Again, *6 on your phone to unmute or left-hand corner if you came in through your computer. We'll give it just 30 seconds or so to give folks a little bit of time. Okay, I don't see anybody, so we'll move on to, is there anyone who wishes to speak in opposition of the application? Again, that's *6 to unmute yourself, and then in the lower left-hand corner, if you came in through your computer. Anybody who wishes to speak in opposition, this is your time. We'll give it a minute or so for folks. Again, just *6 if you need to unmute your phone, lower left-hand corner of the Zoom platform if you're on your computer. This is for the time for folks who would like to speak in opposition. And I do not see anybody. So let's move on to, is there anyone who wishes to provide neutral or agency comment and testimony? Again, *6 to unmute your phone or lower left-hand corner of the Zoom platform. We're looking for anyone who wishes to provide neutral or agency comment or testimony.
Judge Farrar?
We'll give it to,
Yes, this is Michelle, the planning director. I just want to state, since we didn't go through every word by word or every page of the staff report, that we did receive public comment when the notice was issued regarding the public hearing, and I kind of hit a little bit, but we received comment from the Department of Environmental Quality regarding air emissions, so that the landowner just needs to inquire if that site needs to comply or submit a permit, and then from Dogami, that in which we inquired in the staff report, those comments were inserted, but I just wanted to call out that we did receive agency comment, and that was very greatly appreciated.
Great. And again, people can see that inclusion in the documents on the website, right?
Correct. Correct. Yep, it's in the staff report.
Great. Okay, so it does not look like we have any other individuals wishing to provide neutral testimony. So we will move on to applicant rebuttal. Does the applicant or the applicant's representative wish to provide any rebuttal or any last comments? And this would be for you, Mr. Weedman. Anything else that you wanted to add, Mr. Weedman, either as rebuttal or anything else you'd like the court to know?
We started, we tried to do a rock permit here about 5-6 years ago, but it got lost up there and never went through. We just assumed we already had it, but so we're just trying to get this new one to make sure we got everything right, and just hopefully it's approved and it'll benefit, I think, the county. Like you said, with the roads saving wear and tear, having to haul about 3 times as far. So that's all I hope, that you look at it in that consideration, save the roads a little bit, and good benefit for us too. And that's it.
Great.
Thank you.
Thank you. Does staff have any additional comments? Michelle, anything more for us?
I know there's been a lot of emphasis on the roads, and I just want to put a comment out there. Dewey Kennedy, the Gilliam County Roadmaster, was consulted regarding this application, and that's where that condition regarding access and whether that he can at any point in time have at his discretion contact the landowner and say, wait, we're creating adverse impacts to the road system. So he did provide input, and I think he provided opportunities for him to protect and ensure the system is protected through the conditions.
And Dewey, I see you lighting up just a little bit. I wasn't sure if you had something to add on that, or not.
Yes, I do, Judge. I was waiting for my turn. Really, the only requirement that the road department has where the quarry is adjacent to a paved road is either one of the accesses, there'll probably be an inbound and an outbound, both have to be paved. The entrances that butt up to the county road, that way the gravel and dirt doesn't migrate out onto the county road. I looked at the site. It should be a great site for them. And then it's only about a mile from there to the state highway. We've already made the improvements to Baseline Road down there, kind of the safety improvements down there. So it really should be an easy haul for them. That's
Okay.
all I have.
Okay. Any questions for either Michelle or for Dewey, commissioners?
I don't have any. Thank you.
I don't.
Okay.
That was good.
Okay. So we'll move on. The county court sort of has two choices or three choices at this point. We can, one, close the hearing and proceed to deliberations. Two, close the hearing and can carry over deliberations to a time and date certain. Or three, continue the hearing to a date certain. If the hearing is continued, the county court must decide whether to receive additional oral testimony or limit additional public participation to written submittals. So I just need some guidance from the commissioners on how you would like to proceed. If you would like to close the hearing or continue it, if you're ready to proceed with deliberations or carry deliberations over to a future date.
I think we're ready to proceed with deliberations.
I agree.
Okay. Was there something else? Did I miss? I looked down. Okay. So if there are no further questions, then I will now close the public hearing. And we'll move into discussion. So Michelle, it might be helpful to just sort of maybe lay out, commissioners, you'll see in the documentation that you have, the script that I'm looking at, there's actually three separate actions that we're looking at. And so maybe Michelle, if you can help sort of, I don't know if it makes sense to just take them one at a time and deliberate those, or how you guys want to do that. But you're muted, Michelle, by the way.
Oh, sorry. The first question I would pose to the county court at this time is there any concern or amendments that county court members would like to propose to the conditions that I have presented?
I do not have any.
I did not have any either. As usual, Michelle, your report is very thorough and it looks like you've covered everything.
So really,
yeah, I'm in the same. I was going to say I'm in the same boat. I think the Planning Commission. I think the conditional use permit conditions. They looked fine to me. I thought they were spot on. I didn't have any concerns over them.
So really, this is two matters before the county court, and they are attached to a draft ordinance. But I guess procedural wise, and Judge Farrar has said that I believe the commissioners also have a copy of the script with the proposed motions. So if there's no changes or amendments to the conditions, then you would want to proceed with, as proposed, the language in the draft motion, just kind of tick them one off by the other. So we don't want to lump them together. We want to make them separate. So it's very clear that the county court is making an motion to approve the comprehensive plan amendment, which would be CPA 2020-002 as one action. And that the county court is again approving the conditional use permit for an aggregate mining operation, which land use file number CPU 2020-002. And then I believe from there it goes into the draft ordinance stuff.
Yeah, and just as a reminder, ladies, on the ordinance, it's that same two-step reading process that we've done with other ordinances. So we would be doing the first reading if we decided to proceed in that direction today, and then the second reading and adoption would occur on the 2nd of December during our next meeting.
I move
So
to,
do we have motion?
yeah, I'm going.
Or
I
question?
move to approve the amendments to the county's comprehensive plan proposed under CPA 2020-0002 as presented.
Second.
It's been moved and seconded that we approve the amendments to the county's comprehensive plan proposed under CPA 2020-0002 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. So then we would move on to the conditional use permit. Is there a motion regarding that?
I move to approve the conditional use permit proposed under CUP 2020-0002 with the conditions of approval proposed by staff.
Second.
It's been moved and seconded that we approve the conditional use permit proposed under CUP 2020-0002 with the conditions of approval proposed by staff. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, and then we would be looking at the first reading of ordinance number 2020-03. And let me make sure I actually have
The title?
the word. Huh? Go ahead. I just have to find it to read it if you
Find
decide
the
to go
title?
that direct.
Oh,
Yeah, by title only.
I would go ahead to move to have the first reading of ordinance number 2020-03 by title only.
Second.
Okay, it's been moved and seconded that we have the first reading of ordinance number 2020-03 by title only. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, so I will read the ordinance. In the County Court of the State of Oregon, in and for the County of Gilliam, ordinance number 2020-03, in the matter of an ordinance providing for amendments to the Gilliam County Comprehensive Plan to add aggregate resource site number 1002-Weedman as a significant aggregate site to the Gilliam County Comprehensive Plan mineral and aggregate inventory.
I move to accept the first reading of ordinance number 2020-03 by title only.
Second.
It's been moved and seconded that we accept the first reading of ordinance number 2020-03 by title only. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, so we have done the first reading of the ordinance. Again, for those who are following along at home, this requires a second reading, which needs to take place 13 days, at least 13 days after this reading. So that will occur on December 2nd, which is our next regularly scheduled county court meeting. We'll take care of the second reading and then the matter would be wrapped up. All right.
Judge Farrar? If I could just interject, for those that may have not seen the draft ordinance, as it is posted to the website, but if you just missed it, there is an emergency clause so that when the county court does the second reading and final reading on December 2nd, and if we have no opposition and it goes through, it would be effective immediately. This is a land use decision, and when it comes to land use, we don't want the process to be delayed, and this is a financial situation with a landowner, and they have to also obtain additional permits. So we don't want to delay or have this hanging out. So I just wanted to make that clear. Generally, ordinances go into effect, I believe, 90 days after the adoption date. So I just wanted to make that clear. Thank you.
Thank you.
Great. Great. So we will move on to unfinished business. We'll go into item 6.1, which is consider approval of 2021-2026 Gilliam County Strategic Plan. And just to recap briefly, this has been a long road. Back in August, we had approved a strategic planning approach, which included some timelines that allowed us to solicit input from the public in this COVID era. And so, as you'll recall, but I'll just put this on the record again so that folks who are listening in kind of know how we got to where we are. Basically, back in early August, the county court members each put together a SWOT analysis and provided feedback to the chief of staff, basically on the county's perceived strengths, weaknesses, opportunities, and threats. And based on those responses, the chief of staff, Lisa, and I worked together to draft an employee and community surveys to give both entities or both groups of people opportunities to weigh in on where they wanted the court to focus its resources and attention. Those surveys were released in early September and came back in late September. We received 27 employee responses and 140 community survey responses by the deadline. Based on those responses, I put together a preliminary draft strategic plan that was shared with all of the all of the elected officials and our employees for their feedback. Their comments and suggestions were incorporated into that initial draft. And then we held a work session on the 21st of October to review those. And so obviously we went through and we discussed the survey results, talked about the strategic plan itself. And again, I'll reiterate, this is just the idea, this is the first sort of step. This is sort of, if you think of it as sort of an umbrella, this is the top layer of the umbrella, really. The next steps that come after this is to really look at each of our departments, and we'll be asking our department heads how they can plug into these different strategic sort of broad bucket guidance that we're providing. And so, you know, for some of them, you know, when we're talking about ways to improve accessibility to Gilliam County personnel and services, each of our departments, the idea is that each of them are going to be thinking about their own department and how they can contribute to that goal. So I say this as this is a working document, I would say, one that I think needs to be reviewed on an ongoing basis by staff and the county commission, but also once a year looking at these and saying, do these still make sense? Because we had talked about, you know, there may be some things that we are able to feel like we've subsequently reached the milestone or reached the goal, and we want to add the next thing on. So that's sort of the idea, is to make it an accessible document that our county staff can plug their own departments into and sort of help reach these goals. So with that, I will turn it over to you guys for further discussion or questions or comments, or even from the public. This would also be an opportune time if you want to weigh in on these. Obviously, we'll welcome that feedback as well. Questions, comments, commissioners?
Well, my comments are, like you said, this is a document that should be reviewed on a constant basis. We need to make sure that we're, you know, actually performing to make these things happen. I know when the strategic plan was put into place in 2010, when I reviewed that, when asked to weigh in on this, there were so many things that were in that plan that we still are trying to accomplish. So in answer to Mr. Shannon's need for, you know, where do we see ourselves in 5 years? You know, where do we see ourselves in a year? And as we go forward, are we living up to these strategic goals that we have put in place?
Yeah. And one other thing too, I wanted to know, because I did note this during the work session, but I want to put it on here again, that for some folks, they may look at it and say, well, where's healthcare? Where's education? Those are all important to the community. And again, The idea for this document was to really focus it in on things that are within the county's lane. So because there is a public health, because there are health district boards that are elected, the idea is that they set the vision on healthcare, and we help support that. Same with the school districts, so that, you know, we're staying in our lane and focusing on things that are actionable for us to do as a county, and obviously supporting other community partners who are working on those other key components of livability, just with the idea that with goals or anything, you want to have something that's actually actionable by the person who's setting the goal. And so for those who have seen these long sort of strategic plans that included everything but the kitchen sink on what makes a community livable, I just want to reiterate that this document should not be taken as a signal that the county court thinks that healthcare or education or any of those other critical things are not important. We're just focusing the county's resources, activities on what the county has control over. So, Pat, I saw you had unmuted yourself. Did you wanted to weigh in?
Yeah, I'm trying to keep my dogs from barking because we have some people installing the bed right now, so it's a little noisy. But no, I just felt that, and you had commented before that you didn't want to focus on any large business, significant business development, and I really think that needs to be in there. I think it's an important part of where we need to go. And then I think is possibly a missing piece in a plan is, you know, where are we with our assets, our roads, and how does that fall into the plan going forward? And that's really not in there. So it just is so condensed that, you know, a goal to shoot for and a sort of a plan how to get there looked to me like a real good way to go with it. And I'm just, you know, maybe we need to slow down and see if we can add a few things to it. That's my input. Thanks.
Okay.
Judge, I like the way that you mentioned that it is a living document. So if this is things that, you know, this can be something that can be looked at in the first quarter of 2021. If the new court wants to take a look at it again, you can do that, you know, whenever you like.
Yeah, and I think as we evolve, you know, we are going to want to take a look at it, and you know, we can check some boxes and say, well, these are the strides we've made to do this. Now let's look at this, because this is where we need to go at this point. So, yeah, I agree, Pat. There, you know, there are a lot of things we need to think about. We were trying to keep it a little more simple so that we could obtain our goals and not get so far out there that we had difficulty actually making some progress.
So, Pat, what do you think about the approach? I mean, obviously we want your input. You're going to be the new commissioner on our court. What if we went ahead and at least got this document in place? Because what I'm not hearing from you is that anything that we have on there you object to, but maybe we want to enhance. Am I getting that from you? And so, okay, so maybe what we could do is we could pass what we've got, and then once you're on the court, we could look at revisiting this early next year, whether that's first quarter, second quarter, maybe even in connection with the budget process. And then if there's some things that you think that we missed, or once you get into here too, you might have some other additional ideas, we can always enhance that. Do you think that's workable?
Sure, as long as we keep it a working document. And, you know, one of the things I've heard about the other one was it sat on the shelf and nobody picked it up. That's not a good way to do it. So whatever we can do to you know, keep it in the works and keep looking at it and see if we can move the county forward.
Okay, great.
The previous strategic plan was so well done, and there was so much work that went into it. And then, you know, some of the things happened, and then so many of them didn't. And I think it was too long in between where people kind of forgot what the goals were. So if we continue to keep this right at the forefront, then I think that's a good move. Oh, now my dog's barking. What are your dogs doing? My dog.
Mine are laying here quietly.
That's funny. Okay, so based on that, Commissioners, do you have any additions or edits that you wanted to make to the strategic plan, or would we be ready to move forward and at least adopt this version again with the idea that we will revisit once Commissioner-elect Shannon is sworn in sometime probably first or second quarter of next year? Sherry, you're on mute.
My dog went out to bark at Pat, so we're good. I think we're ready to, put this in place for now and try to achieve some of these goals and get a working plan in place.
Great. Okay. So do I have a motion?
Well, you would if I had the right stuff in front of me. But I don't. Leslie.
I move to approve the 2021-2026 Gilliam County Strategic Plan as presented.
Thank you. I second.
It's been moved and seconded that we approve the 2021 through 2026 Gilliam County Strategic Plan as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay. For 6.2, consider approval of resolution number R 2020-41, a resolution adopting the 2020-2021 Employee Policies Handbook. Okay, so this is a monstrosity, as you have seen. This is part of our major review that we've been doing of the county's internal policies and procedures. Again, just as reference, the idea is that we are putting all of these policies and procedures in place, and then every year, every fall, the idea is we'll go back and make sure that those are still meeting the county's operational needs and also in compliance with any new state or federal labor laws that are coming through for us. So what you have before you is the Employee Policies Handbook. Has a whole variety of policies. It's pretty, as I said, pretty large. The template actually came from the CIS pre-loss attorneys. It was modified to align with the collective bargaining agreement. So things like leave, all those kinds of things to make sure those stayed in alignment. And then it was reviewed by the elected officials team. And so this is one of those that CIS strongly recommends that we have updated policies for obvious reasons. One of our largest risks at the county is labor-related risk. And so they are very excited that we are finally getting an updated handbook. But I did want to note for the record that next year we will be renegotiating the collective bargaining agreement. And so this really will probably be in place for about a year, maybe a little bit less. And then once that new collective bargaining agreement is approved, then we'll have to go back and make sure that the employee handbook then is updated to capture any changes in that new contract. So I just wanted to flag that for you, that this is kind of an interim temporary one to get us through until we get the next CBA in place. Questions about the policy?
I didn't have any questions. I've read many employee handbooks, and this is pretty standard.
I had a few.
Okay, go for it.
You don't say.
I didn't.
Go ahead, lay them on me.
Just a couple, but I didn't have as much of a chance to look at it as I had hoped. I kind of ran out of time, which is probably good. But I have a couple questions, and they may seem just like minor things, but they're just things that when I read it, I think, is that realistic? So, okay, on page 14, we're talking about meals right down at the bottom of the page. We're talking about meals, and we're talking about, if you're going to go travel to a conference or something. And there's a part in here that says, if travel from the county begins within an hour of a designated meal time, the county won't cover the cost of the meal, including but not limited to breakfast when leaving home that morning or lunch when the county within an hour of noon time. And I'm wondering, do we need to say that? Can people just, I mean, if people are traveling and they're hungry, can they get food? Or do we have to really stipulate, you know, no, not if it's between this amount of time from when you left. And I just read that and I didn't really like it. I thought that seemed a little too much, unless I'm not understanding a good reason to have that in there.
Yeah, I mean, I think the idea was that I don't think we have an abuse happening, but there's the potential to have an employee who, you know, maybe has a meeting and they're going to the Dalles or something, and it's an afternoon meeting, and so they decide they're going to go a little bit early, and oh, I'll have lunch while I'm there on the county's dime. You know, it's like just making sure that for our folks, obviously we want to help support people who are traveling outside of the county on behalf of the county and making sure that they're being fed and things like that. But I think there was just that feeling of not wanting folks to necessarily potentially take advantage of that by deciding they're going to leave a little early so that the county can pick up their lunch that day, or, you know, so the idea being that, you know, you've got a 1 o'clock lunch, like eat your lunch at 11:30 here and then jump in the car to go to the Dalles kind of thing, instead of deciding that you're going to have lunch in the Dalles on the county's dime, just because you happen to be traveling that day for a meeting. So, I mean, I could go either way, but I could also see where potentially there's some abuses there that could happen. So,
well, is that something that their supervisor could speak to if we had a situation? Like I said, I don't know that this has actually been a problem, but you know, it could always be dealt with by their supervisor. I just thought I was just surprised to see it in there. I haven't really seen that before, and to me it was too much, because I feel like our employees are, I don't know, all grown-ups, and I didn't really think it was necessary. But if you two, if Commissioner Wilkins and Judge Farrar, if you guys think we need to have it in there, then, I mean, I probably won't vote no against the whole policy, just on one, just on that one line.
I agree. I agree.
Go ahead,
I agree with you, Leslie, that we have a really good staff and they are adults. But I have also seen through other employment that sometimes you do get an employee who has to have everything black and white in order to understand what the rules are.
Could I maybe throw in another perspective?
Yes, please.
So part of the reason why this is in there is past policy had some lack of clarity around it, such that several staff were asking for clarity around what they could and couldn't do. And so by adding this wording, it hopes to address and provide that clarity for staff around what's acceptable and what's not, because they do want to do the right thing. And the policy wasn't so clear. So the hope is that this provides that clarity for them.
Well, thank you, because I did not realize there was confusion in the past. So, okay, I'm fine with it.
What do you got next?
This next one, though, this has happened to me, so I don't. We might have to ixnay this next one. It talks about when you're at a conference, you know, when you're at like a week-long conference, say the AOC thing, and you know, and they provide the meal, they provide a lunch, you know, during the conference, and I got to say, sometimes they are terrible. So where it says that if you want to dash out and go grab something to eat, if what they have provided is god awful, I think it's okay for us to pay for that.
Well, and on that note too, is sometimes they don't provide the type of meal that certain types of medical diets, you know, and one person isn't going to say, hey, I can't eat that. And that's all you're providing today. So yeah. I have to go without or I have to pay for my own meal because the conference wasn't able to accommodate my special needs.
Right. So my preference would be to take that out. And I mean, I realize that people, usually we're pretty responsible and we go and you only have limited time anyway, so you're going to go ahead and eat. But based on previous experience about how some of them end up being, I just don't think that we should rule out that someone could grab a sandwich if the meal wasn't really satisfactory.
So do you think that there's enough wiggle room? Because the language is actually says employees who elect to eat elsewhere will not normally be reimbursed. So to your point about if somebody has a dietary restriction and there's not an option there, them just checking in with the supervisor and basically saying, hey, listen, I'm vegan and there were no vegan options. Do you think that's sufficient, or is that an area that we could provide? Because I think it's still, the rule should probably still apply for like 80% of the circumstance kind of thing. So I prefer having language that allows some supervisory for those like off things that happen without necessarily just saying to employees, yeah, eat wherever you want kind of thing, even though the county's picked up the conference costs that included meals, if that makes sense.
Mm-hmm.
So
well,
do you think that language is?
I don't know if
Go
it
ahead,
is, because it says at the very end of it, nor will the county pay for the cost of that meal.
So if I might comment again.
Please.
So again, this is partly born out of employees asking for clarification. What can we and what should we do, not do? So it was hoping to provide some clarification of the general 80-20 rule of expectation. But at the same time, there's always supervisory discretion. If an employee called me and said, gosh, this food is really terrible, they don't have anything on the menu that suits my dietary needs, can I run down to such and such and get myself lunch? I'm not going to say no.
I guess my question is do we need our employees to ask their supervisor of that, or can they be trusted to make those decisions?
Some want to make the call and some want to flow with the trust that's already given to them. It just depends on the person, where they feel comfortable with and where they would like extra guidance.
Yeah, I'm just bringing it up because I didn't really think we needed that in there, but that would be also, Commissioner Wilkins, you can weigh in, and are too.
Well, again, we are employing adults, and I just don't think that we have people that are going to abuse those rules. And if they did have something, I'm pretty sure they would have a good reason why. And if they didn't, then they knew they'd had to pay for their own meal. Sometimes we have to make choices.
So are you comfortable with the language, Sherry, or are you wanting to pull it? I wasn't clear.
Really? I was wishy-washy? No, I'm good with the language.
Okay. Yeah, I mean, I'm feeling like I think the not normally be reimbursed is sufficient enough to allow the employees to know that, if there's something that's just really, like I said, if we have one of our employees is vegan and there's no vegan option, we would not expect that they eat meat because the county paid for it kind of thing. So I think there's enough flexibility in there to allow some discretion.
Okay, on page 29. I was gonna say, it's a good thing I'm not going on in many more trips here. Page 29 under bereavement leave.
Yes.
One of the things I wondered about, if anybody had brought up or not, the people that are listed as your family of who you might want to have some funeral leave for. I just was wondering about niece or nephew. We live in pretty small communities and everybody has a lot of nearby. And I don't know that necessarily 3 paid days off, but I just wonder, what do we do in a situation where it's a niece, it's a nephew, it's someone that is close, lives in the community as well, close to them. Do we even allow them to have the day, just to be able to go to a funeral? Do we allow 1 day, or how are those handled? Is it? do they have to do it? If your niece or nephew has a funeral, do you have to take vacation time? Or is there any funeral leave available?
So let me just ask a clarifying question of Lisa. I can't remember. Is this one of those where the family definition is stipulated by law, or does this come from the CBA?
No, this is defined by law, so we don't get to put in the additional niece, nephew into that particular paragraph. That's a legal requirement. And then if I can try and answer your question about the actual kind of 3 days, what I think you're asking is, can a person take less? Yeah, absolutely. Do they need to use their sick leave? No, by Gilliam County policy, that 3-day bereavement is provided in addition to whatever other accrued leaves that they have. And it's per instance. So for example, if you were really unfortunate to lose 2 listed family members in the same year, each time you would get the up to 3 days bereavement leave that would be paid.
And if I could speak to this from my human resources experience, the more you add to this, and it is law, what's written here, and the more you add to that, the more its advantage is taken of it. I know that sounds bad, but I had been involved where something really had to be put in place because someone was taking bereavement leave every time someone in the community passed away.
Oh,
Okay.
interesting.
Okay. I mean, and I know that is the stipulation. I know that list of the family, the relatives, you know, is already designated, but I just didn't know if we can add more to it. You know, a lot of times employers can be more generous than what's required. So I was just wondering about that. And I think that was about, oh, I had one more thing. On page 41, talks about rules and I guess reasons that people can be terminated. And one of them was failure to notify a supervisor, like if you have to leave work during the shift. And I just thought, you know, in case of an emergency, it would be hard sometimes possibly to be able to notify your supervisor. And I just, that one just kind of jumped out at me too, because I thought there could be situations when someone, if it was a definite emergency with a very close family member, I don't know that notifying their supervisor that they had to rush to the hospital would be the first thing on someone's mind.
Yeah, but again, we're all adults, and I think we have supervisors that are compassionate people and would understand that too.
Well, one would hope, but when you have it written in here like this, they might not be. And especially if they're not fond of that employee in the first place. You know, I just don't want to be able to target anybody for something that's really, you know, I want to be human.
You are human.
Yeah,
that's for sure.
But again, I think for most of the supervisors, I mean, everyone that I supervise works in the building with me, right? And so, and literally walks by my office to get out of the building. And most of the other elected officials who are supervising, or even Dewey's folks, I mean, my assumption is that if somebody walks off the job site, Dewey's going to want to know why they left. And that's just courtesy. Yes. Even if it is an emergency.
I get that. I would mean in a situation where someone's on vacation, your supervisor's gone, or they've taken the afternoon off, or they're just not available close by where you're gathering your purse and you're running out of the office.
Yeah.
So is it prior? So yeah, well, yeah, it says without permission. So basically, yeah, I don't know. Some of these things are written so specifically that, you know, I have heartburn.
What's the, okay, I'm trying to find where exactly the language is though. Yeah, Leslie, what
page did you say?
I'm sorry, I thought I told you what page. It was on page 47. It's
I thought you said 40. I thought you said 41, and it's like, that doesn't say anything like that.
It was 47 and it was like 1.5 inches down. It just says failure to notify supervisor. And then it says a little later about leaving work during normal working hours without permission from your supervisor to do so. And I thought, well, you could get fired.
Yeah, but again, these are instances where where these things happen on a habitual basis, where not my favorite employee who has been doing such a great job all of a sudden jumps up and runs out and doesn't say, I have to leave. I mean, everything has a circumstance behind it. And then when things become out of control and they're doing it habitually, then there's an issue. But
and I get that. I wasn't, and I'm not worried about my favorite employee. I'd be worried about my least favorite employee.
Okay, yeah, right. Because you're looking for ways.
Yeah. That's all I had.
Okay.
Okay.
Hello, poopy dog.
So any other questions, concerns on the employee handbook?
No, and again, it's a work in progress. We're going to look at it again. So it's not something that we can't make some changes to if we find that things aren't exactly working. So, and it's pretty standard these days.
Okay, so do we have a motion?
Yeah, sure. I move to adopt resolution number R 2020-41 as presented.
I'll second. It's been moved and seconded that we adopt resolution number R 2020-41 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay. Up next is consider approval of resolution number R 2020-42, a resolution adopting a cash handling policy. Again, this is part of our ongoing effort to get policies and procedures in place that we did not have previously. So the draft cash handling policy establishes cash handling standards for our employees and volunteers responsible for oversight of cash and cash receipts. For purposes of the policy, the cash handling refers to the collection, custody, and reporting of monies received. The draft itself was one that Nathan helped put together. This is based on the actual procedures that we already have. So I just want to reiterate and sort of for community members who are listening, we're not passing this because we've had a problem with the way that cash has been handled. It's just appropriate for us to spell out expectations for employees on proper protocols. We've got volunteers who sometimes are volunteer drivers that receive cash when they're driving for transportation. We've got other places where there's cash coming in. And this just makes it clear this is the appropriate internal protocols and procedures to make sure that we are accounting for those funds appropriately. So Nathan really, I think, went through and sort of captured what the departments who primarily handle cash are already doing, coupled with years of feedback from our auditors about, you know, what's appropriate and what's not appropriate. And then this was reviewed by the elected officials team to make sure that it worked for each department, because each department's a little bit different. So there were some things, for instance, that that some of the departments wasn't as workable for them. You know, I know, for instance, the Justice Court tends to handle a lot of payments that come in, and so just making sure that it fit Judge Patnode's staff needs and things like that. But each department had an opportunity, or each elected official took a look at it, and this is what we came up with. So any questions on this one? If there's something really technical, I do not see Nathan on here, but Kelly's on here, so she may be able to help too if there's any questions about why we do something one way or another. Questions about this one?
I didn't have any questions.
If staff had the opportunity to look at it and they were okay with it, then I'm okay with it.
Yeah, it was elected officials that looked at it, but yeah, I mean, they looked at it with their eye to how their departments are handling cash transactions, so.
Okay. I move to adopt resolution number R 2020-42 as presented.
Second.
It's been moved and seconded that we adopt resolution number R 2020-42 as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, item 6.4, consider approval of Omega Morgan revised lease for Shutler Station Industrial Park. So Sherry, do you want me to take this one or do you want to do it?
Go ahead.
Okay, so Eric Zander from Omega Morgan contacted Commissioner Wilkins requesting the lease of additional acreage at Shutler Station Industrial Park for some projects they have starting in early January. And so what we have done, as you'll see, is we have an underlying lease already in place. And so basically, this would amend that lease and go back to the originally Omega Morgan had leased the full 35 acres. That's where we're going back to. And so basically we would be doing a third amendment to that lease to just extend the boundaries of what they could lease. And then that also bumps up how much they pay per month. But that's based on the initial lease, which spelled out how many dollars per acre, basically. So that's just capturing those two things. Questions on that? Do we have a motion on the amendment?
I move to approve amendment number 3 to lease of real property Gilliam County Shutler Station with Omega Morgan as presented.
Second.
It's been moved and seconded that we approve amendment number 3 to lease of real property Gilliam County Shutler Station with Omega Morgan as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, so we'll move on to item 6.5, review statewide transportation improvement fund or STIF discretionary grant application. So I don't see, let me look really quick. I don't see Marla on here, but I just wanted to flag for you during our last meeting, we, under the consent agenda, had approved Marla going forward with submitting a grant agreement or grant proposal for these STIF discretionary dollars. At the time, she was going through a state mandated public process to solicit input on what the priorities should be. But the way that the timing worked out was that she needed to submit the grant before we were going to meet again. And so we pre-approved her going ahead to submit that with the idea that we would then be updated on what sort of the key takeaways were from the public. So I'll just flag for you those things. Lisa might have more to add as well, just so that you're aware and the public's aware of what, and obviously all of this is up to whether the state ends up funding us or not. So the couple of things that are on here, project number 1 is a planning project. So Marla applied for $8,500 for facilities planning. This was recommended by ODOT's regional coordinator, Teresa Conley. And basically, I think Teresa's recommendation was that, that Gilliam County really, bus barns were sort of they keep coming up in Marla's plans. And so ODOT's recommendation was that we look comprehensively at what the needs are and do an assessment with a consultant to kind of lay out a plan for what's actually going to be needed today and in the future to support storage for our vehicles and other transportation related equipment supplies. And so Marla applied for 8,500, and then depending on whether we get a 10 or 20% match, you'll see in your briefing what that equivalent is would be for the county to chip in. Project number 2 is right-sizing the fleet and replacing vehicles. Marla's note is that the Toyota Siennas have really sort of risen to the top as the best vehicles to use in their transportation needs. And so the recommendation was that they purchase 3 Siennas to help meet some of those demands for accessibility and other things. So the project total would be about $150,000, so $50,000 each. Keep in mind, those are like the fully equipped, you know, fancy vehicles. And then it shows in your briefing those estimated match requirements. And then project 3 is Arlington storage for transportation assets. Again, this goes to the bus barn question. So the idea is we would do phase 1, which is the planning, and then the rest of the phases you'll see kind of outlined there. We would then hire a surveyor, purchase a portion of land. There's an empty lot area north of the existing bus barn in Arlington, hire a project manager to do the engineering and construction, and then actually construct the vehicle with the estimated total price of $145,000 with the matches that you see there of $14,500 or $35,000, depending on whether we're approved for a 10 or 20% match grant from the state. So let me see. Marla also wanted me to note that all of the matching funds, again, I think this is an important point, they're paid out of the brokerage contract revenue, interests that they have on the accounts, and vehicle sale revenue. So none of these matching funds that are listed here come out of general fund or tax revenue. They're all coming from those other sources. So mostly this was just to keep the court informed about what Marla's going after, and I'm not sure when she will actually hear back. I'm guessing probably sometime early next year on these projects. But any questions I'll try to answer, or Lisa may know more than I do, or we'll just write them down and have Marla get back to us. Questions about these ones? Sherry, you're on mute.
I am. I was trying, my dog's barking at Pat again. I'm going to blame him for it anyway. No, I didn't have any questions. Again, Marla's always right on top of what funds we can get and where they need to go, and impressive work she does.
Agreed. If I have any questions, I will just contact her directly.
Okay, sounds great. We will move on to item 6.6, which is an update regarding the building codes agreement. Just wanted to let you know that we've been going back and forth between the state and the city of Boardman on an agreement for the city of Boardman to provide building code services. Obviously, this is not new. I've told you this a couple of times that we've been working on it. The state and the city finally came together on an agreement that both of them felt comfortable with. And so I have sent it over to our legal counsel as of this morning and asked her to take a look, make sure she's comfortable. As long as she is comfortable with that language and doesn't see anything super red flag-ish that we have to raise and negotiate, I would suspect that we may have an agreement by the end of the year for the court to approve. So I'll just keep you posted on that, depending on how quickly she can turn things around. Again, the idea is really that, I mean, it'll be pretty straightforward on our side in that I think partially I think it's by law, but the proceeds from those building permits and things have to go to the people who are providing the actual service. So all of those will go to the city of Boardman. The county would not pay anything in addition to that. And Boardman's commitment has been that they're not, at least at this point, going to charge us for travel fees or additional fees They think because of the activity that happens at the Port of Morrow, they are more than self-sustaining. They don't need to increase rates on our folks. And the hope is that, that their inspector, who would be based out of Boardman, particularly for north end projects, could be more on demand, and for south end projects, you know, at least trying to be in the county at least one day a week, which I think will be fantastic for our contractors to be able to rely on a consistent schedule, and have somebody that's close by. So anyway, that's some good news, and I'm hoping that maybe, fingers crossed, by our December 2nd meeting, we might have an agreement to look at. If for some reason we miss that deadline, I likely will I will have a baby probably by the 16th of December, but we may need to look at scheduling a special meeting either late December or early January. I'd like to get that done so that our contractors are getting better service and can make that transition over. So
yeah.
Questions on that?
Anything we need to do between December 2nd and the end of the year, a special meeting, anytime we can take care of business.
I'll be around too.
Sounds great. I'll keep you guys posted on how quickly Christy gets it turned around. 6.7 is an update regarding the Condon swimming pool. So as you recall, we had a discussion about this last meeting, sort of where we are, and I see Catherine's on too, so maybe she can kind of supplement this. I think where the City Council landed, and Catherine, you can correct me if I'm wrong, was that they're sort of on hold on the lease with the school district for now. And the idea was that they would like to get some community feedback on next steps. So they'll be helping, and I volunteered us as well to help facilitate that conversation with whatever we can do to get feedback from the community. And so the lease itself is just sort of in a holding pattern while we have the broader discussion. Did I capture that, Catherine?
Yes, yes. And so we did have our first Park and Rec meeting to talk about it. And so our first step is to get a small local committee together of probably about 7 to 9 people. And at that point, which right now, Steve Schaefer, Kaylin Lane, Tom Fatlin, and Jim Hassing will be on it. I'll just administer it. And we're asking for some other members that we're going to then, I think the first step we have to do before we decide whether it's going to be regional or just locally is put out a survey to figure out how important it is to the community. And so what we determined at the council meeting is that, and at the Park and Rec Committee, is we are going to wait until we get the survey results before we decide if there's enough interest to go back to the school and get a lease at that point. I think we can all agree that the pool has probably met the end of its life. And so what we're trying to do is figure out if we're going to limp along for a couple years and look at possibly a new pool, but again, that means that we have to figure out how we're going to build it and how we're going to fund it. So the survey is going to hopefully tell us that if the community wants a pool bad enough, and we're hoping the survey will go to all of Gilliam County and hopefully even some of Wheeler County since they participate, and we'll move on from there. So I'll keep you updated. I'm hoping before Tom leaves, and well, we have to all be on Skype or Zoom now anyway, but he's taken off in a couple weeks for a couple months, hopefully, and we should have our first meeting before he leaves. So that's
Great.
where we're at. So
good job.
Yeah, we'll keep you posted.
Questions for, I was gonna say, questions for Catherine on that?
Yeah, I'm glad to hear there's a committee and that we're looking at all that feedback. So thank you.
You're welcome.
Great. So 6.8 is update regarding the Lonerock Bridge change order request. Again, this was on our agenda last time we met. Had to do, there was a recommendation from Anderson Perry that they had felt that the change order, that the county did not owe the contractor additional money, additional funds, but we had agreed that we would go ahead and just run that by legal counsel to make sure that we didn't miss anything. So Carrie Connolly, who is also with Local Government Law Group, she's a procurement specialist, and so she took a look at that contract as well as the documentation that Anderson Perry provided and came to the same conclusion that Anderson Perry did. So, so what we went ahead and did is just have Anderson Perry, who was the project manager on that, reach back out to the contractor and let them know that that was the determination that was made. So Dewey's been in the loop about that as well. And, but I just wanted to close that loop for everybody on the record that that was what the city or our county council had come to the same conclusion that Anderson Perry had. And for those who want to go back and read the whole history, if you look at our last meeting, you'll see all of the documentation for that in Anderson Perry's kind of walking through what occurred and the reasons they came to the conclusion they did. So any questions on that?
I don't have any.
Okay.
Before we move on to the next item, could we take a quick break?
We can. Why don't we, it is 2:50 now. Why don't, is 5 minutes enough for you guys? You need a little bit more time. Okay, so let's come back. Let's come back at 2:55 and we'll resume.
Thank you.
Of course. We'll just wait for Sherry to join us and then we'll get started. Hey, Sherry, you guys ready? Sherry, you set? Okay, so we will come back into session then and go right into 6.9, which is discussion and possible action regarding allocating CARES Act funds for Condon Chamber of Commerce Small Business Grant Program. So a lot has happened in the last 24 hours. So let me just bring you up to speed on why this was originally there, what has changed, and kind of where I think we might want to consider going. So as a reminder, as part of the CARES Act, which was federal coronavirus relief funds, the counties each were allocated a certain amount of money to help cover COVID-related response efforts. And so, those funds have to be expended by the end of this year, so December 31. We were in a situation where we had about 50,000 left of those CARES Act funds, and we're having a hard time figuring out how we were going to spend them before the deadline. And so originally I had put this on here thinking that understanding there's a second wave that's happening of case counts, that our businesses may be seeing sort of a second wave of impacts on their own businesses, and that perhaps it would make sense to top up the Chamber's grant program that they've been administering on the county's behalf to help support our local businesses. And so that was the original intent, why this was put on here. What has happened since was yesterday, the governor's office announced that they would be providing $55 million to the counties to help support small businesses, and specifically providing each county a minimum of $500,000 to do that. And so we do not know the parameters of that. We don't know when the funding will come out. We don't know if that will be on a reimbursable basis or if they're going to give us a lump sum. So all of those details are still a little murky. And so in the meantime, what I did was have staff go back and look and see if there was anything else that we have, any other costs that we've incurred that could potentially fit under those CARES Act requirements for those that $50,000 that we definitely have to spend by the end of the year. And what we have found between our senior meal site and between the Veggie RX program that's under Teddy's portfolio, that we think there's enough in there that we that would cover, we can go and ask for reimbursement for those two programs, and that would basically wipe out our CARES allocation for the end of the year. So my recommendation is going to be that we go ahead and do that so that we can shore up those two programs for the extra costs that they've been incurring. And it's not something that necessarily needs court approval unless you think that's the wrong direction to go and just want to voice that. Otherwise, it's just, it's an administrative thing where we go to because we've already expended those funds, basically. So we're asking for reimbursement from the state for monies that Sabrina and Teddy have already spent for those two programs, because both have been heavily utilized for obvious reasons from the public. So that's my recommendation on that piece, the actual original CARES Act allocation. On the $500,000, what I wanted to try to get, at least from you guys today, is some direction on whether we want to, how we want to manage those funds. So what we do know for sure right now is that those funds need to go directly to businesses who've been impacted by COVID and can show income loss based on the pandemic. And so, but other than that, and that the fact that we'll get a minimum of $500,000, that's pretty much all we know at this point. We don't know when those funds would be released. We don't know any other thing, whether they'll say that counties have to run that directly or that they can subcontract with another entity to do that. We don't have those guidelines yet. But I did want to at least game out some different scenarios and get your take so that once we get those guidelines, I have some direction on where to go, because I think whichever direction we end up going, likely we need to have something in place by probably the end of the year or early next year, like first couple of weeks in January, to know how to disperse the funds. So, so really, I think what we're looking at is two options to weigh. One is whether the county wants to individually disperse those funds. So we would have to come up with an application, a way of really documenting that the businesses that are receiving those funds were in fact impacted by COVID-19. So that would likely require the businesses to submit financial information to the county directly. And whether that would be to the county court or whether we designated a team of people within the county that made those funding decisions, that would be one option. Pros of that, obviously, we have control of that, the whole process. We can make sure that that follows state guidelines to the rule or to the letter of the law. Downsides of that is potentially, because all of those financial records then become public documents, there may be some folks who don't feel comfortable having their business financials become part of a public documents like that. And so that's one option. The second option is to do similar to what we did in the springtime, which is to find an outside partner, whether that's the chamber or some other entity who helps administer that program on the county's behalf. And so if we went down that road, we would likely do similar to what we did with NORCOR today, which is sign a subgrant agreement, basically stipulating that whoever is administering it on our behalf, the expectation is they're following those state and federal regulations for what's acceptable and what's not, and reporting back to the county on how those funds were expended. Plus side of that, the outside entity, particularly like a nonprofit like the chamber, definitely are more agile in being able to make funding decisions. So rather than have to wait for the next county court meeting kind of thing, they're able to sort of meet much more regularly. And then of course the privacy for businesses who may not want to disclose their business financials. Cons of that are obviously that process then becomes less transparent because they're not a public entity, so they're not subject to the same public records and public meeting laws that we would be. So I just sort of wanted to weigh those two options with you, or put them out on the table and get some direction from you on kind of what you're thinking. And obviously, if the state comes to us and says, no, it has to be dispersed directly from the county, then we'll do that and we'll figure out how to make that work. But if they give us options, I wanted to kind of get a sense of which path you guys would prefer.
Well, if the chamber, if the Condon Chamber of Commerce was interested in taking that on again, I know they did a good job with the first wave this past spring. If they didn't, I haven't heard anybody say that there was a problem. If they aren't interested, would we be able to create a group of our own to do that, like a committee that would be set up to review those in a private manner and not make it public?
Good question. I'd have to look into that a little bit more. I'm assuming if it's a committee that we're setting up, they're going to be subject to the same public information requests and public meeting laws that the county court would be, or, you know, any of our other departments would be. That's my assumption, but I would need to run that by council.
Yeah, that was my concern, was if the county put a committee together to disperse the funds, then they would be a county entity.
Mm-hmm. And again, the state might not give us an option. They may just say that this is how it has to be dispersed. But I just wanted to kind of, knowing that it will probably be a tight time frame to get something in place, I just wanted to sort of get a sense of where everybody was, what people were thinking. Leslie, what do you think?
You know, I thought the chamber did a good job.
Yeah, if they're interested in helping us out again, that would be great.
Yeah, and they alleviated the you know, the public information aspect of you know, people not maybe wanting to apply. So yeah, I didn't have a problem with the chamber if they were interested.
So
okay.
we are on a tight.
Yep.
Oh, go ahead, Kaylin.
Go ahead, Caitlin.
Good afternoon, commissioners and judge. This is Kaylin with the chamber. I just want to let you guys know we are positioned and ready if you guys are willing to, you know, give us this opportunity to help the business community. And we are positioned to act immediately as well. We have an established grant review committee that encompasses, you know, a large variety of the Small Business Development Center. We have business professionals from the community. And if somebody from Gilliam County was interested in serving on that committee as well, that would absolutely be an option.
Well, Judge, will we hear about this before? Can we discuss this at our December 2nd meeting?
Of course, yeah, but I mostly wanted to get something, not something in place, but a sense of direction. Because if the idea was that, for instance, if we wanted to go with something like the chamber, I think we would still have, obviously we have the discussion, you always have the option to change your mind, but I would want to start getting legal counsel working on drafting any legal documents, just with the idea that, again, like December 2nd is likely to be my last meeting before this baby comes. And so I didn't want to leave you guys hanging with no direction if there was a clear path that you guys preferred. So, but yes, I definitely was planning on putting on the December 2nd meeting agenda, and we should have clarification hopefully from the state as early as next week is what the governor's office has been telling us. But I did put in a plug that giving counties flexibility on how to administer the funds would be very helpful, so that we have some different options. So we'll see. I've got a meeting with the governor's office this afternoon, and so I will reiterate that with her as well, to make sure that they're clear that this would be important to have some flexibility in deciding how to administer the funds.
we want to get everything we can in place as quickly as we can so that we can get these monies out to our businesses as fast as possible. You know, if we have the money, we want them to have it, so.
Yeah. So does it sound, am I hearing that there's an openness potentially to partnering with the chamber, assuming that the state allows that to happen?
Yes.
Did I hear that?
Yes.
Okay. So what I will do is I will definitely put this on for the second. I will start a conversation with the state and with the chamber about what that would look like. So making sure that if the state has certain stipulations, that those are captured in a grant program, that so the chamber may need to modify some things in how they're distributing funds to meet state requirements. But we can work with legal counsel to kind of at least start to outline what that partnership would look like, so that even if it's not me, if you guys do a special meeting later in December to get everything wrapped up, we've at least got the conversation and the outline for what we need to actually get this rolling. Because I'm in agreement. I mean, with the freeze that we have right now, again, I mean, businesses, I think, were sort of holding on by their fingernails, and so the more that we can help pump that money back out into the local economy, especially during what is a slower time of the year for them, the better. So.
Yeah, we would want to make sure that the applications have all the necessary criteria in them as well. That might be different than it was in the spring. I haven't seen one of those applications, so I don't know, but that was just one of my concerns, that we make sure that it captures everything, the rules that we have to abide by.
Yeah, and it is a big sum of money. So, so I think it can do some good if we can get it out quickly to folks. Anybody have any comments, questions, concerns about the approach for now? Or members of the public, because this is literally sort of breaking news, like we were just told about it. So that's why this whole shift that just happened. Okay, so I will keep you guys posted on what I learned from the governor later today and next week. And then I will start the conversation with legal counsel, the state, and the chamber to see what we can figure out on a partnership for administering the funds. Sounds good?
Yes, please.
Okay. Let's move on to 6.10, which is discuss red zone designation request from Avangrid Renewables. And I see, let me see, is Brian still with us? Let me double check. I see you. Okay.
I'm here.
Oh, good. I figured you would stick around, but then I didn't see you for a second. I thought, uh-oh, I hope we didn't lose you.
No, nope, sticking around for sure.
So I'll just turn it over to you, Brian.
Okay. How much time do I have? By the way,
so
is there
we don't have a limit. So feel free to take some time, and I know there was quite a few people who were interested in weighing in too. So.
Yeah. Hey, Liz, I'm trying to share my screen. I was wondering, it looks like you need to enable it on your end.
Okay, Lisa, can you do that? I'm not the techie person, Brian. I have to have my staff help me.
Nor am I.
I have to ask Teresa to do it, as I don't have the permissions.
Okay. Looks like it. Screens here. Great. All right, is it up in front? Everybody can see it?
Yeah, just came up for me.
Okay. Great. Well, Thank you, commissioners, for the opportunity to come before you again regarding the red zone and advocate for its establishment. I know I've been persistent about it, but you know, my persistence is only there because there is a serious need for it. And we are running out of time for a couple of our projects that need some certainty and some help in getting there. But for the sake of those on the phone and for Commissioner-elect, I thought I'd just start with a summary too here as well. But let me first back up again. Brian Walsh, Avangrid Renewables, 1125 Northwest Cooch, Portland, Oregon, 97209. So today the agenda, I just have an Avangrid Renewables overview. Our Avangrid presence Pacific Northwest and Gilliam County to familiarize people with our presence. You know, activate the SIP agreements, active SIP agreements in the county, and just kind of an overview of the red zone requests and economic benefits, and talk about a little bit of an example of what, you know, these projects mean as far as dollars during construction and afterwards, and some of the labor, average property tax savings, and the depreciation, construction timeframes, and then average property tax savings for a project such as, you know, we'll use Montague Solar as an example, and solar depreciation, and also then just kind of the red zone process as I understand it, just in case you had some questions and just kind of conclusions, and then any time for questions. So most of these are to address the questions that the court posed to me, which I responded to in letter, but wanted to kind of go over and reiterate here for the general public and for others. So if that sounds okay to you.
Sounds great.
Okay, there are no objections. I'll dive in here. So, and I'll skip over these kind of rather quickly, but Avangrid is part of the Iberdrola group. Avangrid Renewables is the Iberdrola Renewables, which is a Spanish company and then one of the largest utilities in the world. We have 14,000 megawatts across a dozen countries, and then you know, here in the United States, you know, we operate in generation assets in 20 different states, but we have a presence in 28 different states, and now up to 7,500 megawatts of owned and controlled wind and solar assets. So, and our U.S. renewable headquarters is here in Portland, Oregon. So this is our backyard. And yeah, and then the Avangrid Renewables headquarters, the corporate office is in Orange, Connecticut. Like I said, we're headquartered in Portland. We're established in '95, but really started with our first assets in '99. So almost 20 years ago, we entered into our first power contract. So as far as the Pacific Northwest goes, that dates back to State Line, that dates back to our Klamath Cogen facility. So we've been around for a while. So this is just a rough map to show where our presence is in the United States. So we're pretty diverse in our locations, with the exception of the Southeast, and we're getting there. But you know, we made our bread and butter is wind energy, and that's our specialty. But we have more recently, as the market has gone to, is solar and solar generation for obvious reasons. I'll jump into here in a little bit. Any questions?
Brian, I don't think your slides are advancing, or maybe that's just me.
They're not.
They're not. Huh. On this, my screen share, they're advancing. So everything I see.
I think, Brian, you just need to start your slideshow. We're just seeing the regular view.
You're not seeing any slides?
We're just seeing your initial slide, and then down the left-hand side, the first previews of the first 5 slides. I think if you go to the 7th menu along, slideshow, and click start slideshow, we should start seeing them.
Okay. Give me a second here. Thank you for stopping me. Let me, I mean, for me, I'm flipping through the slides. It says I'm sharing my screen, but let me stop sharing and try and start again for a second. Hopefully that fixes.
So maybe start your slideshow and then do your screen share.
All right, it's restarting here. Let me know what's up. Do you see any slides yet?
We just see your original screen, the kind of splash introductory screen. How about if you manually click each slide for which one you want to speak to? Does that change it for us?
Yeah, it's working on my end, but sorry about
like Murphy's
this.
Law with technology.
I know. It says I'm presenting it. I'm able to flip back and forth, and I can.
Brian, if I may, this is Kelly Smith, Gilliam County IT. I believe if you click on the screen share button at the bottom of your screen, you should be able to select which window you're sharing on your computer.
Mm-hmm.
And hopefully the slideshow is one of those windows.
Yeah, hold on one second here. Hold on, I'm gonna stop sharing for a second and then restart. How about now? Are you at, can you see the agenda slide?
Hasn't quite popped up for me yet. But previously it took just a second for it to jump up. So could be just a small break. Okay, I can see the agenda slide.
Oh, you can. Okay. Great. Hopefully this will work. All right. I'm moving through the slides. Let me know if it's working for you now. Can you see the map of the U.S. power assets?
It's still the agenda slide for me. One other thing we could try is you could email it to Teresa and Lisa in my office.
I'm experiencing a lag time here. Oh, yeah, let me try emailing it to Lisa.
And then she could maybe just share it from there. And if you just tell her when to advance the slide, maybe she can sorted out on her end. It's hard to run a slideshow and talk. I've tried it before. It's not easy.
I can use all the help I can get. Bear with me right now. I'm going to ask a few other people in my household to get off the internet to see if that speeds it up. So excuse me while I yell at my children. All right, that. So Lisa, it's on its way. It might take a second just because it's a larger file.
Okay.
Anyways, for the sake of time, I'm just gonna kind of keep going through my slides here, and you'll just have to trust me. We have a large presence in the United States in developing wind projects. We have around 70 wind projects, and we have 4 solar projects, operating solar projects, with many more in development at this time. So, and then skipping through my presentation. Hold on one second here. Appreciate your patience here. All right. Anyways, I'm gonna be talking. It's on its way, Lisa. Let me know when you get it. So, so Avangrid has had a presence in Gilliam County since 2006 when we built the Leaning Juniper project, which we sold to Pacificor. And Avangrid has constructed over 5 wind projects totaling 600 megawatts in the county. And Avangrid currently operates 502 megawatts of renewable energy projects in the county. Avangrid currently employs 26 permanent employees working in the county at above county average wages. And Avangrid has paid over $30 million in property or SIP related payments to date. So I thought that was relevant to raise that. So the active SIP agreements in Gilliam County, currently you have 5 active SIP agreements. Invenergy's Willow Creek, 72 megawatt wind farm. Avangrid Renewables Pebble Springs, 100 megawatts. Leaning Juniper A and B, 200 megawatts. And then Montag's 201 megawatts. And then also the Caithness is Shepherd's Flat, a portion of that project that's under a SIP agreement. So the red zone requests an overview of the economic benefits. I mean, the current incentives that are available to renewable or to solar projects specifically is there is a payment in lieu of taxes, which is $7,000 per megawatt of nameplate capacity. It doesn't provide that much incentive for a solar project due to, when it was set and the pilot was established, the cost of solar energy was probably 3 times as much as it was today. So that $7,000 per megawatt, back then when they established it, it did provide a good incentive for solar, but that is no longer the case. There isn't much savings. It's less than 10% over, what we pay over ordinary taxes. And so, and on top of that, the pilot expires at the end of 2021 if you have not brought your project online. And due to recent spikes in construction labor materials costs for wind and solar projects, we're seeing a lot of challenges to the economics to over what we assumed due to a sharp spike in recently into the costs, particularly with the high voltage contractors. There's a labor scarcity due to a lot of the natural disasters that we've had in the United States, Puerto Rico. All of those are having an effect on the labor pool. And on top of that, you've just got solar energy and renewable energy. It's the cool thing to do these days, right? And so there's just a lot of construction of renewable energy projects that are going on right now. The red zone incentive, is just one way to help assure projects to remain viable and reach their construction and operations. The Montag wind construction local spend, demonstrates that the economic benefits to the local economy from having constructed, a project far outweigh the property tax that are abated. And so I'd provided some statistics in the letter I'd submitted ahead of time and in emails prior, but total the combined Gilliam County local spend and landowner payments were 10.4 million. And that's just the local spend that we tracked on it. And so just for background, how we have that information is we require under our contract with our EPC providers, which, let me slow down, EPC is engineer, procure, and construct. So those are essentially the construction companies that design and build our projects. In the case for Montag, it was RES, Investis was the turbine manufacturer, but they tracked on all of the local spend. So they knew what the impact was, and they had to report that back to us. And also, they had to turn in receipts for per diem from all the contractors or what they paid for those employees. So we were able to track that number, but not down to the granularity of where they spent it. But there were some obvious places where we knew that the construction spend for Montag was within the county, and we could say that with certainty. So the tax revenue projection for Montag Solar, go back to that, it's projected for the years 1 through 3, it's approximately 4.5 million. That the standard red zone abatement would be providing that benefit. The extended abatement for years 4 and 5, if approved by the county, could require an applicant to provide additional funds to the county in exchange for those abatement years 4 and 5. So it's a tool that you as the commission have in your toolbox. So, if you weren't willing to accept it for a project that's within a red zone that is seeking the extended abatement, that you can condition it with other payments or other conditions too as well. I tried to get a hold of Art Fish last night, yesterday, and this morning, and wasn't able to. So I didn't know if there were any other conditions, but I think it's up to the county commissioner's creativity on how they could condition those approvals. So. And the total estimate for property taxes for years 6 through 25 for Montag Solar, for example, is 17 million. And we have a real opportunity to construct this project, but really we need the county's help. The Montag local construction spend, and I really would love to have the slides here to help me out in illustrating these, but we'll share them with you afterwards. So I'm just going to
Brian, I'm sorry to interrupt. This is Gabe Gordon Harper from Avangrid Renewables. I could try sharing my screen with the slides since I have a different bandwidth, if that would be helpful to folks in the commission.
that would be great if the commission's open to that. Gabe works with me at Avangrid, so we can try a different.
Yeah, that's fine.
I am not getting your email, Brian, so that's probably a good alternative.
Okay.
Do I need to
what's your
request-
part?
I'm sorry, go ahead.
I was going to say, I think Teresa's wanting to know who she needs to get permissions to.
Sure, I'm on the screen as Gabe Gordon-Harper.
Okay, great.
Okay. But anyways, I'll continue talking through this right now. So the Montag went local spend for the per diem that they track on wages and per diem spend, 15.5 million during construction. And so, what are your questions? Was, how do you know what was spent in the county? And that's difficult, but you have to make the assumption based on there were people living in the county, they ate every day during there. A lot of people live during construction within the county. That per diem, you can make an assumption that a portion of that was paid. So Gabe, if you can go one slide up. Back up. Yeah, here we go. Thank you. And so that was at 15.5 million of per diem. The local spend was 9.285 million. Of roughly what 7.4 million was spent within Gilliam County, and I'll break that down on the next slide for you. And then payment to Gilliam County owners since the leases were executed since 2007. So Montag was out there for a long time, and we were paying for those leases and the option to build that project for a while there. And so that was over 3 million before we even got to the start of construction. And then there were installation payments that went to the landowners. And then over, the life of the project, there'll be $42 million paid out in royalties to those landowners that are part of the Montag project. So that includes the Gentai, those property owners with wind turbines on their property, and 9 different landowners that have an overhead transmission line on it. So anyways, Gabe, if you can flip to the next slide, I can break down at least that portion of the 9.285 million of local spend. So this is what our contractor spent, and I kind of highlighted the items that I thought were easily identified that would have been spent within the county. So fuel for equipment and trucks, mostly they're fueled low during the day. Erosion control measures, that's silt fencing, things like that, or materials that are there. The local hardware store, which was easy to track. Farmland support were things that, for instance, Kevin Hegwood and other landowners that were providing services to allow for the construction of the project that were entrepreneurial and saw a need and helped the project out. Recycling that went to waste management. Local office supplies, local geotech, aggregate supplier, that's rock that we, for instance, from a rock pit, Guy Weedman is permitting today. So that gives you a rough number of local, rock and aggregate suppliers, and then site security was local as well. So, and the largest one is the foundation installation, which is 6.4 million. But even if you assume that half of that expense, was outside the county, whether it was rebar or other sources of the foundation that were sourced out, or you could roughly add that up, half of the foundation and the remaining items, and that's how I arrived at 7.4 million of that 9.25 was spent within the county. So there's room for error in there, but the bottom line is with the 3 million in land payments made up before construction, and this during construction, there was 10 million of local investment, and that's not counting any of the 15.5 million per diem. So I can't break down the per diem and accurately for you, but if it's safe to assume that a portion of the workforce that was and that per diem, food, gas, lodging, was spent within Gilliam County. But combined with all of those things, 27.2 million in total spend. Gabe, next slide. Thanks. Commissioner Farrar, you had asked about what does employment look like? So this is, let me just explain the slide. Basically, it's a curve for an employment and peak labor. So these are how we tracked, 5 different or 6 different wind projects and their labor. And so your x-axis is the labor, the number of laborers, and of course that's over the time, and on the bottom where we had multiple wind projects across the country. But this is similar to solar too as well. And your labor is going to start slow, with the wind project, you start cutting in roads and doing your civil work and ground clearing work, and then you start, for solar, you start driving piles, and then behind them come the panels. And then the electricians coming through making those connections behind them. But in the middle of the project, you have all phases of the construction going on, and that's your peak of your labor. So for Montag, our peak workers were 271 on site, which Montag here is the orange dots, if you can see those. But it is similar to solar, that you have a peak in the middle of the process when you have all facets of the construction going on. And it's much like wind. Solar is an assembly line process. So, when they're finishing on the south end of a solar site, the north end, they're still driving piles. So, and it matters on your labor, how many workers you have. Your period of construction can be shorter or longer depending on how much labor you throw at construction. So, any questions there? I'll pause for a second. Okay, Gabe, will you jump to the next slide? So then back to jobs. So you said during Montag, it was a peak at 271 employees. Our rough measure and ratio for solar techs is every 50 megawatts of nameplate capacity, we would be 1 new technician. And generally then a manager, and then usually half-time we have an administrative assistant, which might be local or it might be at another location. And then Avangrid technicians are hired prior to commercial operations date. So you had a question on when they would start. Usually we bring them on a few months before we're commercially operating, or six months beforehand. So they hit the ground running when the plant goes operational and hits that commercial operations date. And in addition to this, our technicians generally have manufacturers representatives, because we have warranty period, and so the manufacturers have their own representatives on site for maintaining and making sure that we don't have any warranty claims. So those employees, and this is common with wind and with solar, are on site. So for instance, for Montag, we have 7 Vestas employees that are full-time and will be for 10 years, in addition to our own wind technicians at the plant. And so that's how part of our 26 full-time employees that we have working in the county right now, 7 of them are Vestas employees. Next slide, Gabe. You talked about construction timeframes, and in particular for Montag Solar. So Montag Solar, or any solar project, generally is depending on its size, but one of Montag's size is probably a 9 to 12-month process, depending on, again, how much labor is available and how quickly they can go through the installation and commissioning process. So, but There's a little bit of variable in there, but yeah, 9 to 12 months. Usually will be mechanically complete in 9 months, where all of the facilities will be installed, and then we have a couple months where like it's a burn-in period where we're testing and commissioning the substation, the inverters, and all the panels. And so we go, and at the end of that commissioning, then we go commercially operating, which is the first day that we get paid from the customer. We can anticipate construction. That was another question, could for Montague, if we get there with the project economics, could be in Q1 or Q2 of 2021. We have that flexibility as far as our permit in scheduling and other factors that we could. And then local contractors. You had asked, like, how do local contractors get hired and take advantage of some of this construction work? So we keep a list of all the local, providers and service providers. Believe me, there's a list that goes out there in the industry when these projects are permitted. And so it's very visible when there's a permitted project and they reach out and offering services, wanting to know when the project is going online, when the RFP process is happening. So we keep a track of lists and a spreadsheet with all of those contractors and their contacts and what services they provide. And that's given to our EPC bidders. So when they put their bids together to bid the project, they have that list. It's up to them to reach out to them. Avangrid doesn't directly contract with anybody but the major EPC contractors. So it's up to those, the eventual EPC winner who builds the project to subcontract from those other folks. Any questions there?
Yeah, I do have a question about the employees who would be the long-term employees. You're estimating around 5. And what type of training do they require to get one of those types of jobs?
Yeah, I mean, generally we look for a background in, in electrical work or similar work. We have a lot of our wind technicians that are chomping on the bit to add solar to their resume. So we'll see a lot of those folks that will probably take some of our staff from that has expressed that interest into managing and learning how to maintain a solar farm, and then backfill for some of our wind projects. Yeah, generally, we hire a lot out of the Dalles and out of the Columbia Gorge College. We've hired successfully from there, throughout the years. So, but yeah, I don't know if I answered your question on what kind of background, but
yeah. Thank you.
Yeah. And then part of a red zone approval, one of the conditions of the red zone approval is that we post all job offers through Workforce Oregon, and that those are posted and those jobs are posted locally. So it's one of the requirements of a red zone. And also just worth noting, like the restaurant suppliers, food services, catering, those are all included with the list of vendors that go to the contractor. All right, next slide. So specific here, to give you an example with hard numbers, like with the Montague Solar project, we're estimated for the savings for the Montague Solar, should it have a 5-year red zone with a pilot for years 4 and 5, is 6.7 to 7.5 million would be the tax that we would be abating. And then aside from that, any other conditions on tax, conditions that the county could put on us for years 4 and 5, then would reduce that benefit. But over the life, this is represents about a 30% reduction over the full property tax for a 25-year life. And so then this slide breaks down just what it is for the first 5 years that we would pay in ordinary taxes, so you can get an idea of what the depreciation is. But in year 6, we're still paying over $1 million. And then again, that total would be for year 6 through 25 is 17 million. So if you're roughly looking at a 30%, if it was 21 million, before, but ordinary taxes would be around 21 million, and then after the abatement, it would be 17. SIP agreements offer little, benefits to projects of this size. There is this benefit for a SIP agreement once it gets to a large solar project or enough, or a wind project once it gets to enough of an initial investment. So that first 25 million in value is taxable, escalates 3% every year, and that's what makes it a difficult hurdle with that escalation over a 25-year life or 30-year life that. During that SIP period, that it isn't a huge incentive until a project gets to an initial investment that's large enough. So, for instance, why Pebble Springs wouldn't have benefited from a SIP agreement or Leaning Juniper 2 on its own, but because we entered into a SIP agreement with the county that incorporated Montag too, all 3 projects, we were able to get value out of it. The problem here with why we couldn't, pair together multiple solar projects and enter into a SIP agreement is because once the first project comes online, that SIP agreement or that SIP abatement period, or that starts with the first project. So unless you were able to time 2 projects being built in the same year, or 1 year apart or something like that, you start to lose the value of the SIP agreement unless you have scale. I guess that's the key takeaway. So anyways, just the statutory fair and total SIP payment for Montag Solar will be on par with the property taxes under the 7K, 7,000 per megawatt pilot scenario. And it's, again, less than a 10% benefit over ordinary taxes. So. And just the SIP agreements provide about a 30% reduction in ordinary property taxes. So it's very similar to what the red zone is offering. It's the same level of support and reduction over ordinary taxes. All right, next slide, Gabe. You asked about depreciation before. And so we kind of touched on this before, but for years, we'd still, after year 6, we'd be, paying over $1 million a year. The total for years 6 through 25 is over 17 million. How long would that tax base be? I think it's important to, just because Avangrid models at 25-year life, we actually believe that the projects are going to last much longer than 25 years. Currently, the tier 1 module manufacturers give you a degradation warranty out for 25 years. I mean, they'll guarantee that the panels are only going to degrade in what they can generate by a small percentage year over year. And so they're warranted out to 25 years. So even if it's a 0.5% degradation year over year. So at the end of 25 years, the panels are still 80 to 82% efficient. And so that gives those panels a lot more life beyond 25 years. So you can expect, the key takeaway is here, you can expect that there's going to be tax revenue beyond 25 years. But also the rapid advancements in solar technology, just like we've had in wind over the last 10 years, presents this opportunity for wind projects to be repowered, just like the Leaning Juniper project did last year, completed this year. But anyways, it refreshes the tax base again, and that's the same thing that will happen likely with solar, in that 12 to 15 year category. If there's an incentive out there too as well, that's attracting it and making it beneficial to repower, and then you can just take the panels off. They're all made in roughly the same size. Take the old panels off, put the new, more high efficient panels on, and away you go. For the most part. So it can be really simple, and again, refresh the tax base beyond 25 to 35 years with a repower somewhere in the later years. All right, next slide, Gabe. Anyways, I wanted to just talk about a little bit about the red zone. Should you like the tools that, as I understand them, and Art Fish has explained them, but I might not have captured them. But like the next steps for a red zone, the benefit is that it attracts economic development. similar to an enterprise zone. You know, when you have a red zone or an enterprise zone that's established, you know, it's kind of a welcome mat for economic development, you know, and we as the industry, I can't speak for everybody, but we look for these tax benefits. You know, I look on the Business Oregon site and for the designated red zones, which are listed here, like the 13 that are already established. And these are a good indicator that the counties are have a zoning solar in their zoning code or welcoming solar development in their county, and it's a place to start. So, but if you should set up one, you need to designate a zone sponsor, and likely that would be the county would be the zone sponsor. That's the way it's worked in other ones, or the city. Like the last one there is the city of Pilot Rock. They're the zone sponsor. But you have tools to limit it if you are concerned about lots of projects taking advantage of the red zone. You can establish a geographic area and limit the geographic area of the red zone and where that benefit is. Also, you can set the cap on the initial market value of a red zone up to 250 million. Is the cap on it, but you can always refresh that if, like for instance, if Montague and Oregon Trail got built, their market value would nearly probably take up all 250 million of that initial red zone. So then, you know, no other project would be able to go back through it, or the county would have to establish or decide to refresh that market value and that cap. And that's happened in Crook County, and other counties are doing that because the tools work well. Like there's, you know, Crook County has, I think, 8 permitted solar projects in it with 3 operating, the most in there. But they were one of the first ones to adopt a red zone in the state. So after that, you need to notice Business Oregon and submit the approved resolution. If you were to set up a red zone, it's very simple. Compared to an enterprise zone, which is very onerous. I don't know if you've gone through the enterprise zone for Washington, but Michelle can probably tell you how difficult that can be. But anyways, there's a form on the Business Oregon site. It's fairly simple to fill out, and that resolution that you could adopt. But then again, once it's established, the county commission has control over the, you know, whether an extended abatement is granted. And you can also condition, you know, that extended abatements for years 4 and 5 and place it on, for instance, requiring, you know, some payment be made for those years 4 and 5. I'll skip down. That's just the list of the counties that have them. Oh, one thing that's noteworthy here on the dates in which a lot of these red zones were established. A lot of them are more recently in 18, 19, and 20. It's just an indicator of where the industry is going as far as like solar development and when they're being established. So, next slide, Gabe. So, you know, just to summarize here, the red zone is an attractive tool for economic development. There's 12 other counties in one city that have them established in Oregon that we're competing with. The Gilliam County projects are competing with. The economic injection to the local economy during the construction period is greater than the dollars that are abated in a 3 to 5 year situation. Small and medium-sized projects needing an incentive plan to help them compete with other projects in Oregon, especially past, you know, for solar past 2021, there is no pilot. You know, the Montague Solar project, for instance, is you know, up against, you know, deadline and possibly not going to be able to make a 2021, end of 2021 commercial operations date. And Oregon Trail doesn't have a customer right now, but we're actively bidding it. But we desperately need some certainty on a small project like Oregon Trail that doesn't have economies to scale as the larger projects to be able to compete with some of these RFPs and other opportunities. So renewable energy development needs predictable economics. We need to be able to count on these incentives being in place years in advance. And when we go to bid these projects, we bid projects 2 to 3 years in advance of when they come online. So the development period cycle is just longer for a renewable energy project. and we need to be able to look in the future and see what incentives are going to be there for us. And so we just need that certainty. So, you know, having a red zone in place now will benefit projects in the future. Like I said, we're late to the game for Montague right now, and Oregon Trail desperately needs some help. So, and more so, just the county has provided the same level of incentive before with SIP agreements. And so we're just asking, the red zone provides the same level of support the county in renewable energy projects in the past. Also, near-term PPA like opportunities are closing. Utilities are indicating in their IRPs, which are the integrated resource plans, that they're long on renewables. A lot of them are just procuring right now is because the production tax credit for wind projects is sunsetting, and they rather get a cheaper wind project and more competitive wind project price now, knowing that the PTC is no longer going to be there. And so that's, I think they're procuring early just to take advantage of the certainty and savings with the PTC for wind projects now. But by all means, they're indicating they don't need renewable energy until 2025, 2027. And also just the load growth is flattening just because of energy conservation measures and also COVID. It's definitely, you know, Puget Sound Electric canceled their RFP for more power because their loads just dropped tremendously because of COVID. But anyways, and the last point, Montague Solar and Oregon Trail, the F6 started construction deadline is 2023 under that permit. So we've got a window of opportunity here, and we could definitely use your help. I think that's it. I think we're up to questions. So hopefully you're still with me, but I appreciate the time.
Sherry, you're muted. Did you have a question?
No, I just don't like that look. I'm sorry. I'm a born and raised Guild County girl that grew up on a wheat farm, and that makes me very sad.
I understand that argument, Commissioner Wilkins. You know, there's a lot of wheat that's growing in Gilliam County. You know, the Montague Solar Project and Oregon Trail together would likely only take up 1,600 acres of all the dryland wheat that we have, or you have in the county. So I know beauty is in the eye of the beholder, and I can't change your opinion on that one, but.
So I have some questions.
Sure.
I want to dig back into local spend and start just by asking, I mean, you're using numbers from wind. We're talking about a solar project. So I'd like a comparison on how that differs. Because obviously the logistics of bringing in wind turbines has got to be different than the logistics of bringing in solar arrays. So what's your anticipated spend based on those differences in projects? Because this isn't really an apples to apples comparison, obviously. If we're looking at solar, wind is not a comparable in terms of construction costs. So,
yeah,
so that would be
right.
helpful.
Yeah, that's a good question. So, I mean, the labor is going to be similar, you know, as far as when we go, and you're looking at this list, and we're still going to need porta-johns, we're still going to need local electrical contractors, but we're going to need more of them. You know, fuel for trucks, we're still going to need those. Erosion control materials, we'll likely need more of those. Just because because you're doing the whole fence perimeter around the solar project, which would be around 2 square miles, but it'll be similar there too. You know, the big one here would be foundation installation, and that one, of course, would be a bigger number here for wind as far as aggregate goes. But on the same time, you're drilling thousands and thousands of piles And so though it's a different type of installation, but you know, there's still, it's pretty intensive as far as the labor and equipment that's out there. So yeah, and we're still going to have site security. So your differences are going to be rock and water. You're not going to need as much rock for a solar plant because you're not making concrete or as much concrete here. And that would be a large difference as far as that on the foundation installation.
And then I wanted to dig into your local spend dollars just a little bit more, because again, you know, I think the argument we're making to, or you're making to the public and to these taxing districts that are giving up $7.5 million in revenue is that the local spend is going to more than make up for that. And so I think it's really important that we're clear about, did these dollars actually land in Gilliam County? Because if they landed in Boardman, that doesn't, I mean, it'd be cheaper for us to write the city of Boardman or the county of Morrow to a check than this. So I'm curious, like the fuel for all equipment and trucks, those were local contracts. Those weren't trucks that were coming in from out and fueling up on their way in.
I mean, there's some of that, Liz, for sure. There's some of that's there, but they also brought fuel trucks out there because it's just inefficient to have to run all the way back into town to fuel trucks up and things like that. So, you know, there was on-site sourced fuel that was brought in for that. And so it's not just like the guys that are driving the pickup back to Boardman, spending the night, or the Dalles. I mean, there is a portion of that. That's why to be conservative here, I'm not suggesting like all of this was local spend at all. I think even if you lopped off and said that, you know, half of the 15 million in per diem and wages, because most people live on paycheck to paycheck, but a lot of these guys do. In their per diem. So even if you lopped off the 15 million in wages and per diem, you know, and cut that in half, you're at 7. And if you don't think the 9.8 million or agree with what's highlighted here was spent locally, and the 7.4 million, I assumed 80%, but I'm pretty confident in what was spent here. But take that in half, right? The 9 million. So take 4.5 plus the 7.5. You're still at 13 million of that 27 million that was spent locally. And even if you discount it further, like go down to 25% of it, you're still at a match for what the 7.5 million or 6.7 to 7.5 million that we're abating here. And maybe there's less local spend with the solar project than the wind. But yeah, in a lot of cases, you're going to have more labor. So there's a little bit more per diem spend with a solar project, just because you have more laborers for a longer period of time during that peak period. So it's rough to say, but yeah, I'm not trying to imply that all of that is local spend, but I wish
because I also question, I mean, because part of that calculation you just gave me is payroll. So you said there were 271 employees sort of during Montague 1, but how many of those were Gilliam County residents that you hired? Because otherwise all of that payroll left the county. So I would, per diem, I think maybe you can make an argument that as they're coming back and forth, they're stopping in Arlington and gassing up and, stopping in Pat's establishment and having lunch. But payroll, unless you were hiring Gilliam County residents, that's not a local spend.
Well, their wages, they would spend them beyond their per diem, which is supposed to be a reimbursement for food, gas, lodging, those things. But their paycheck then, while they're living in the regional area or local or within the county, would be spent on their own entertainment. So a portion of that. So yeah, let's say they save a portion of that. But that per diem, though, is a large portion of 15.5 million. And we did have people living in the county. There were people renting houses. I mean, we added them to, our list of vendors too. And I know down in Olix, all 5 trailer sites of rods were all taken up for a year. And now, there were other houses and rooms, and Reitman's rental house and Weatherford's rental house, multiple rental houses that were all occupied. And, I know up at the Arlington Industrial Park now, you've got RV spots up there, and I don't know if those were in place during Montag or not, but like those will get snatched up too for Montag Solar. So yeah, and part of that's spent on catering and food and the River's Edge and the pheasant and the food that was delivered to site. That all goes against per diem, and that's local. But again, I don't have it broken down, Liz, to the zip code. Like I would love to just, tell you like this is the exact number that was spent in the county. We just don't have that granularity. But I think there's some safe assumptions here.
And then local geotech, what is that? Who did that for you?
Geotech,
Almost $1 million of your local stuff.
What's
so
that?
I'm just curious because I'm not sure that there's what is that? Local geotech.
Geotech. So your geotech would be the guys that come out. They could drill holes, do soil resistivity testing. They could be the guys that are out there surveying and marking off, environmentally sensitive areas too as well. I'm not 100% all of, what goes into that in geotech. I just know the range of services that we typically can procure from a geotech provider.
Yeah, Gilliam County doesn't have geotech or electrical contractors, so none of that was.
Well, I know that there's certified electricians live within the county, and you don't have to be union. They could be union or non-union, and which we had both union and non-union folks on the place. And geotech can also be the guys that come out and test concrete. So I don't know. I can't break down that number completely. But again, I don't want to get. I mean, even if you whittle that away, like, what's a reasonable number is what you have to ask yourself at that 27 million. So
what you're telling us, Brian, is if the court does not agree to a red zone, that you're going to totally abandon the Montag solar project.
No, but I think, thank you, Commissioner Wilkins, for getting to the point. And I think you've all raised it in one way or another to me about why would we, and I think it gets down to the basic question of why would we give a project that's already moving forward a red zone, incentive and as one of you put it, why would we subsidize PGE's customers, power rates, at the expense of the county and Gilliam County taxpayers. So I'm at a precarious point right now with the project, or Avangrid is right now, due to the construction pricing that has come in, at multitudes higher than we thought. I mean, well beyond what we ever, expected it to be. And so when we bid the project to the customer, we assumed that there would be a certain return rate with that based on how we estimated what the capital expenses to build the project would be. So we have come in astronomically higher than we anticipated. And so when my company looks at these investments and they look to move them forward, if we have moved more than 20% off of our initial estimated cost, it causes us to go back to our parent company and our management company for reapproving the economics because they've changed so drastically. So, and for my company, I compete with projects in other countries for our company's capital. And so we have to make a justification, and especially when our pricing, our assumptions deviate this great, to go back to them. And so we're in that position right now where I have to go back to them. And I have to go back to them with an alternatives analysis of, could we build this project somewhere else with a better return, even if it entails delaying bringing the project online by a year. And so that is part of the analysis that's going on right now that I have to present forward. So right now I'm trying to put the best case forward for the Montague solar project so we can keep it going. And on top of that, it's Oregon Trail too, as well, as we have active customers that would like that, but I don't have pricing certainty. And really without, a red zone establishing that, it just doesn't price that well. And likewise, Oregon Trail is tied to Montague, because if Montague gets built, a lot of the infrastructure that's required for Oregon Trail gets paid for by Montague. And so both projects, I just want to link them together as they both kind of hang in the balance, because Oregon Trail doesn't stand a chance without Montague solar going forward. But my whole point is to get certainty and get a red zone established so that the Montague project, when weighed against other alternatives, looks as good as possible. And frankly, the Gilliam County is always, it was a reasonable assumption. And I maybe, made the assumption, told my company, yeah, Gilliam County has always supported our projects. And this is a similar incentive that they've approved before for wind projects. And it really was my logic for, saying that we could probably have a high likelihood of establishing a red zone. So we counted on the red zone being approved. And maybe I'm over my ski tips on that, but I found it was a reasonable assumption. But either way, that's the key decision that we're in on now. We have our pricing on construction. That's not going to get any better. We have multiple parties that responded to it, and they're all higher, and that's across the United States. That's not going to change. There's just a scarcity of labor. And so one of the last tools that we have here to make the project competitive is the red zone. And that's why I've been pesky and persistent. And I apologize for bombing your email box, but if it wasn't important, I wouldn't be pushing it forward. And I'm most grateful that you're allowing me another opportunity to present the case, but it's a decision time for the Montague project.
Where's the Oregon Trail project? That's
right next to it.
Right next to it.
Right next to it.
I mean, it's all in the same acreage.
Oh yeah. So the majority of Montague is on Bert Athern's property, which is farmed by Weatherford's and the Weedman brothers' property. That right there on the west side of Highway 19. Just on the west side of Weatherford Road, then would be Tim Holtz's property and another Weatherford relative that owns that property too as well. And so that's where Oregon Trail would be. And that's a 41 megawatt project compared to, Montague Solar being 162. It just, it's a smaller project. It's the remainder of our interconnection capacity at Slat Substation off of Ray Road. So it's the last available interconnection capacity out there. It's just small enough. It's just going to be challenged to build a project that small. So, and we're looking at a wind solar hybrid, a wind solar storage hybrid. We're looking at all kinds of creative ways to do it, but it just becomes an expensive project when it's that small. And if we are to get a customer sooner, we could move forward with the Oregon Trail and build it at the same time as Montague. And that's really, that's my pipe dream, is that we're able to get certainty on the red zone, make the project Oregon Trail competitive, and then, go out and have it bid by the same contractor that would build Montague.
Brian, I have a question.
Sure.
When we,
Go ahead, Leslie.
When we spoke the other day, and I had a few questions for you, one of the things we talked about was conditions, additional conditions that the county court could decide to place if we decided to go ahead with a red zone. And looking at like year 4 and 5, I heard the number thrown out like 200,000, but I wasn't sure if that was 200,000 for year 4, 200,000 for year 5, or if it was, if it was 4,000 we were talking about, or if it was 200,000 total.
No, I'm suggesting for both, one for each year, 400,000 total, or $500,000 total for years 4 and 5.
Okay. The other thing I saw an email from somewhere saying that the first 5 years we were talking about $1 million to the county tax base. So I was kind of wondering where that number had come from.
I think that's I don't know if that was year 6, the first year after. that I was responding to, that we're
No,
still more than,
it said in here, the solar project will still contribute a 1 million to the county tax base over the initial 5-year period.
Yeah, I think that might have been, Leslie, a email that we received from the port director, Peter Mitchell.
Yeah. Well, I was just wondering
Aggregate.
information that we didn't have.
Yeah.
no, I mean,
Or
it's a,
information that wasn't accurate.
mhm. It's a complete abatement for the first 3 years and then, condition there. So I can't speak to that one.
But year 4 and 5, I mean, that is up for negotiation, correct?
That's correct.
Pat, I saw you took yourself off mute. Did you want to say something?
Yeah, I was just going to state that I think that, the court needs to look at years 4 and 5 as something you can negotiate and get comfortable with in an effort to move the project forward. But just from the small business standpoint, little guy in Gilliam County with a couple little bitty restaurants, and you start talking about the local spend and what's needed, just from my own personal situation with what happened on Montag 1, it didn't matter how much they spent in the town. That deal was huge for us surviving at the time. And I don't think we would have made it through the first 2 months of COVID had that project not preceded it, because that's what carried both my businesses through until we finally got some assistance to come along to keep. I got down to where I wasn't sure we were going to make it to the next day. So when I looked at, to me, whether you have it or don't have it is a big deal. And the more that you can have makes these small businesses just that much more likely to survive in these rural communities that it's tough to survive on anyway. And then when you start talking, we get, I think Brian's indicating there's some risk we could lose it. And you start talking about the tax revenue, the taxing districts could lose in the first 4 or 5 years. What could they lose in 25 to 35 years if we don't move forward and this doesn't happen? So I just want us to consider all of those facts, because there's a lot of talk about as the SIPS funds begin to tail out and taper off. We're not real sure. I was on the AOC conference yesterday listening to a lot of the calculations for what the turbines are going to be assessed at, and it gets real confusing. I don't think we have a clue where that's going to end up, but how do we backfill some revenue for the county that's guaranteed revenue when that starts happening, and making sure we don't give that away. And then it's just huge. And the way I'm looking at this is being open to whatever comes along in the future, and being a county that's, receptive to big business. And I've hit that a few times today from a few different angles, but man, if we don't incentivize as much as possible bringing big businesses in this county, I think we can talk about housing and fixing the downtowns and small business development, and having things like we talked about the other day, laundromats and car washes and taverns that are open and pharmacies just don't happen if we don't in some way keep pushing to bring in more industry and more large business, significant business revenue into this county, especially looking down the road.
Do we lose our small area living once we bring all that big business in? Do I move to Monument?
We get to make a decision on whether we want to be a sustainable county or we don't. And I think it's the same thing you can say when you look at whether you like the appearance of solar. For me, and being independent or wanting to be independent in the world today, I really don't want the neighbor farmer telling me what kind of weed I'm going to plant. It's my ground. I want to be able to make what I can make off of it. That's my decision. And I realize it's got to be within, the regulations and requirements that are in place, but I still want the opportunity to make money with my property if I own it and support my family in that way. So, and I've had a few conversations with some of the local people, and there's people that don't want to see good farm ground go out and solar go in until you mention that. Well, how would you like your neighbor telling you what kind of wheat to plant? So, it's how you want to look at it. And I'm a small businessman that's been struggling for 6 years. We make a little money through the summer. And we struggle to get through the winter on what we made in the summer, and then we start all over again. I've been doing that for 6 years, and the best year we've had was absolutely last year when phase 1 of Montague went in. And like I said, there's no way we would have made it through the first 2 months of COVID without that project preceding it.
But Pat, that's putting a Band-Aid on because it only lasts so long.
Yeah, I mean, my concern is, and this is what I
don't know. I'm not sure what you meant by that, Sherry. A Band-Aid on what? Because to me, the Band-Aid is if you're trying to save SIPS funds to live a little longer into the future without backfilling tax base in some manner, someday you're going to fall off the cliff. It runs out and there you are. So if we don't figure out a way to build a tax base to maintain our county the where it is today, as revenues drop off, if they do with the SIPS funds tailing out, then I don't, we talked a little bit the other day about the increase in the budget over the last few years. And so we've got a lot of issues.
Go ahead, Lynn. Well, I was going to say, listen, from my perspective, yeah, we want to expand the tax base. We are open for business for renewable. Obviously our history shows that, but here's my concern that I keep coming back to is every indication, Brian, is that you are going to build this thing here. And so for me, I struggle because you've signed a power purchase agreement. Your agreements are already, we just today took 2 actions on this court that are clearing the way for logistics for this project to be built. You signed a power purchase agreement with PGE and said in your press releases it's coming to Gilliam County. That was after we had told you we didn't think we were going to do a red zone. And so, I know that myself because PGE called me and asked me for a quote so that they could talk about how important it was that they were sending tax dollars to Gilliam County. And so now you've inked all of these deals. You have construction, I understand, that's coming in that's higher. But what I struggle with is that our taxing district's responsibility to make the numbers work for you when PGE, basically, I'm struggling to see if you're going to build this anyway, what the upside is for us, because you've signed an agreement, have you not, that says that you're going to be providing power to PGE by the end of the year, 2021. So if you're not, would you just walk away from that agreement or?
No. Hey, Gabe, can you switch to the slide number 6 for me? So Liz, here's the thing. The difference is right, like I talked about, we bid a project at a certain price based on certain assumptions, and those assumptions have changed greatly. And so, like I said, I'm required to. My company is required. Avangrid Renewables needs to go back to Iberdrola and the management committee of Avangrid Renewables to present the new economics. So we're not in the business of making building projects that are less than our cost of our capital, and so. We're talking about that, then they ultimately can make the decision, and they have before, to either try and move a project, replace it with another project, or walk away. There's a penalty that comes with it, but to not make money off an investment for 30 years, over paying a penalty for walking away from a PPA, they've done it before. And that happens in the industry, and so that's what we're trying to head off doing. That's the point where we're at. I'd say if we if we're just our construction pricing came in even closer to where we were, I wouldn't you won't be pushing so hard on the red zone. I just, I take my lumps. We apply for the pilot and take the small benefit that it would give us for a pilot agreement and walk away. But like, I need a bigger improvement for the project, and that's why I'm here. And so, yeah, my project, part of the alternatives analysis will be looking at these other projects that are on the map right here. We've got Tower Road. We've got project in Bluebird in Clickitat County. And we have down in Bake Oven, we have a 303 megawatt fully permitted project down there, and we're going to build the first phase, and it's going to pay for all of the upgrades necessary in the Gentie that the second phases will benefit from. And it's a compelling economic case there too as well. So I can't say what they're going to do. Like I said, I'm here to advocate for the project, for Montague to stay in the county and improve the economics as best we could, so we don't have to go down to another alternatives. But once we go down that path and they make a decision, there's no turning. They won't turn back at that point. Like, we're at a go no go situation, and so what you're gambling with is the potential for the revenue for the county beyond that. And then I just want to take go ahead, Liz. You have a question.
I was going to say, but I want to challenge that just a little bit, because the county, so Morrow County, the Tower Solar that you're talking about, Morrow County doesn't have a red zone either. So how does that why does that work in Morrow County and not in Gilliam County? They don't have the incentive package you're looking for. So, isn't the red zone an Oregon thing? So does Clickitat County have a comparable red zone designation? I mean, that's not a federal designation, that's an Oregon program.
I know. It's an Oregon designation. So, Clickitat County, that project is, to be honest, Bluebird, it's our Bluebird solar project. We're adding electrons onto an existing Bighorn 1 and 2 Gentie. So the CapEx cost for that project is very low. And that's why it becomes really competitive, because not only we have an O&M presence, we're building it next to our existing O&M presence there. We're using the Gentie and the 9-mile Gentie back to our point of interconnect with Bonneville, and we have some really lower costs. So it's just, they all have different situations that make them more competitive, but we're leveraging existing infrastructure. We're doing that too with Montague, but we still have to build, we're still having to build a Gentie back to the Montague substation. Which gets to why I prefer to put my projects out of sight in the general site and not along a major highway. But in order to be cost competitive, we needed to be closer to the existing infrastructure to make the project work, Sherry. So I was saying that for your benefit. I normally wouldn't pick that out. I try and find places where it's hidden away. That's what I did really successfully in Prineville. I tucked it away where no one could see it. And that's my goal, but not always possible.
Yeah, and Bake Oven is nothing but scrub ground, so more power to the solar there. I mean, it won't grow anything and it won't feed livestock, and so there you go.
Hey, Brian, back to the question about Morrow County, because when we were talking about it yesterday, I wasn't exactly sure what the answer was to that either. We talked a little bit about how it was zoned already in Morrow County, but I wasn't quite sure what the response was on that.
Yeah, thanks for pulling it back. So, it's a lower voltage too. So the lower the voltage, your interconnection voltage, generally lower cost that you have. So something that Tower Road has going forward is it's a 115 kV interconnect versus a 230,000 kV at Montague. And like I mentioned, at Tower Road, it's the property that we have is zoned light industrial, and solar is an outright allowed use in light industrial in Morrow County. So our permitting is it's an over-the-counter permit to put that. It's building permits. And so there's a key discretional CUP action that needs to happen with that. So because it's an allowed use. And we're saving, over $1 million in just permitting and not having to go through the FSEC process like we did for Montague. On top of that, there are a lot of state FSEC conditions for annual reporting, compliance, surveying, for your mitigation parts or otherwise, that we have an annual cost for an FSEC project, which is really expensive. And we just don't have those at Tower, for example. We don't have those at Bluebird. We have those at Bake Oven. But again, you've got other projects that are paving the way for those costs. So, we all the costs on one project, the first phase of it. So,
haven't you already? I was going to say, haven't you already eaten the permitting costs though for Montague? I mean, we keep seeing SEC, amendment number 4, amendment number 5. So isn't that already? Didn't you already bake that in? I mean, at this point, you've already sunk the cost,
not really,
right?
In hindsight, Liz, lesson learned, we probably should have just started over and started from scratch with Montague. There were a lot more complexities of trying to take a wind permit and wind conditions and split it into 2 site certificates for a solar project. They're just not apples to apples. And so if we did it all over, we probably spent more money and more time doing it via an amendment than we could have. We should have just started from scratch and permitted it with its own site certificate. But lesson learned. But yeah, there was a lot of we went through all the hoops and costs that we would have gone through had we started from scratch.
And so I have another question that's just sort of, I'm just throwing this out here as like sort of a hypothetical. So if Bake Oven already makes more sense for you, you already have the red zone, why spend all the time trying to convince us to do a red zone if you've already got shovel-ready permitted land that already had, not that I'm encouraging you to go to Wasco County, but I think it begs the question for the public is, if what you're telling us is this is a prime site that you could move it to instead of Gilliam County, why didn't you just do that? I mean, why are you spending so much time trying to land it in Gilliam County if you've already got a site that's got everything you need and will meet the bottom line for you?
The answer is, Liz, we might. You're absolutely right. We're at the end of our rope, so we will go down the alternatives analysis and we'll do it. And the decision might be, yeah, we'll move it over there. I'm just trying to, put the best foot forward for the project, and that's why I'm here today. And so, yeah, it's a gamble, but my company might make that decision, to move it. But it's easier, Liz, to answer your question. It's easier just to keep it where it is right now. We don't have to go back and talk to our customer again. We don't have to revise our schedule. There are some, yeah, it is simpler to keep it where it is. There's no doubt, right? But when it comes to the returns, when you're talking about a 30-year return on a project, they'll make the decision that's best on the long-term return rather than the short-term pain. I hope that answers.
Commissioners, yeah. Commissioners, do you have additional questions for Brian? Because I know there were some folks in the public who had expressed an interest in weighing in, so I wanted to make sure we got to folks.
No, let's move on. We have another meeting in 40 minutes.
So I'll open this up to the public because I know that there was some feedback people wanted to give. And so just as a reminder, if you called in, it's *6 to unmute yourself. If you're in on the Zoom platform on your computer, it's in the lower left-hand screen. You can unmute yourself. So do we have any public comments, questions, feedback on what you heard?
Can you hear me?
Yeah, go ahead.
Yeah, I'm part of the Oregon Trail project. I farm all the ground that's in that project. The other part belongs to Ann Flores. She's, I don't know if you guys knew Fielding Weatherford or not, but his daughter over here. But anyways, I guess it's concerning me. I had some other stuff I was going to talk about here, but it seems like you guys are kind of hostile to the wind project, or the solar projects, and that kind of bothers me because Gilliam County has always been known as a county that's friendly to development and all this kind of renewable energy, and even back when they put the landfill in, you guys are friendly to that too. And I guess it's just kind of bothered me. But anyways, back to what I was originally going to talk about is I farm about 15,000 acres altogether in Morrow and Gilliam County together. So this project you're talking about, this Oregon Trail, is only like 2% of my ground I farm, so it's not going to adversely affect my farming operation. And I've also heard one of the commissioners talking about how they like to see wheat, outgrown. But you know what? Before we grew wheat here, it was all sheep out in this country. I guess maybe they don't like sheep, see the sheep go either. But
Yeah, you're right. I didn't like that either.
We got to get with it. We got to change with the times. And if you guys are going to rely on wheat farming, the county's going to be gone because there's not enough profit in it to sustain it. The way we're going now, the farms are going to get bigger and bigger. Just like what I'm farming now, there was probably, I'd say, just the last generation, my dad's generation, there would have been 10 farming. So, in another generation, there's just got to be farmers left. There's just going to be a couple farmers farming the whole county, and that's not sustainable. You can't run the county that way. So, you've got to move with the times and accept this new technology and new sources of income that are coming along. And I just don't understand why you'd be opposed to this red zone. That's basically the same thing that all the other wind projects have gotten around here. And in the long run, it'll increase your revenue for the county in the long run and pay for a lot of your programs. I just don't understand why you wouldn't approve it. But anyways, I guess that's all I have to say. Thank you.
Thanks. Is there other folks who are on the line who would like to weigh in?
This is Guy Weedman. Can you hear me?
Go ahead, Guy.
Yeah, I've just, we're over there on 680, 40 Highway 19. I have the ranch over there. And I'm talking for Weedman Brothers and Weedman Farms as owners over there. And my daughter lives there at the house there and farms there. And, we got 8,400 total acres over there and about 7,000 of farm ground. And, the big project is 1,200 acres that's they're trying to put there right there behind the house. And, yeah, we thought about it quite a bit, having the solar right there. It was hard to, we looked at it, but it's been tough in the farming business. It's, we've had a few good years, but you have more bad years than good years, and it's been tough to make it. And what we've, our family started farming in 1882, and we've expanded, and, I got, my brother and I got 2 kids each, and they're stayed here in our business, and we have another hired hand, so we're, 7 people altogether, families. And, that's what we've been trying to do is keep our kids here in this community to survive and keep going and have them here. I mean, it's a perfect deal for as a parent to have your kids here. And the wind over here in Sherman County has helped us survive and let us expand to Gilliam County when we bought that over there. And now this solar deal, it's going to help us that much more. And, we want to keep surviving, I'm hoping my grandkids will stay and farm. And hopefully we're farming for a couple hundred years. So it is hard taking it out of wheat, but, we've had a lot of good years there and a lot of bad years. And so I think it's a good diversification for us and for the county. And, it's been important revenue to the Sherman County. It's been important revenue to Gilliam County. And all the projects that they have done over here in Sherman County, I don't know everything in Gilliam County, but they've really helped the community here. And, including school, building the school. And you guys have always given, the tax breaks Tax incentives help keep the projects here, and times have changed right now. With this COVID deal, it run the costs way up, and we're afraid we're going to lose this project because it is tight because of the costs. And so I think you have to look at it, and is it worth giving a little bit up now and not get anything for the next 20, 30 years? I think that would be a big loss to the county. So I'm just asking you to look at it hard that way, look at it and helping us as a family, keeping our families here in our communities, which I think is important. And I'm proud that my kids have all wanted to stay here, and my brother's kids too. Stay here and be in our business and do this. And farming's not easy. And, you know, like I said, we've had 3 times more bad years than good years. So this has helped us tremendously, and I'm just asking for your support. And I thank you.
Thank you, Guy.
Thank you. Anybody else who's on the line, or even folks who've already spoken that maybe have other additional points they want the county court to consider? Again, if you dialed in, it's *6 to unmute yourself, and if you're on the Zoom platform, there's a little mute button on the lower left-hand side of the screen. Additional questions, concerns. Trying to see who else is on that may want to weigh in. I'm not seeing anybody. So I think, commissioners, I'm looking for some direction on where you are on this request.
There's one question. If I know you've given me a lot of time, so if you want to cut me off, feel free to. But I think it's
Go ahead.
a relevant point. So if I take my Avangrid hat off, which I will right now, and I'll just talk about like just the industry in general, where we are as far as renewable energy. So the production tax credit for wind has sunsetted. So the solar is going to have a monopoly in the near future because it has a permanent 10% investment tax credit, where wind has 0 permanent incentive that's out there. It's the only form of energy that doesn't have a permanent, incentive that's built in. The production tax credit started dropping down at the end of 2016. It went from 100% to 80%, and then to 60 to 40, and it's gone at the end of this year, unless you bought it back in 16, 17, 18, and then you could get those varying percentages depending on when you bought equipment or started construction. So the writing's on the wall for wind. Solar's already reached pricing parity with some of the best solar sites. So we're building the Golden Hills Wind Farm in Sherman County right now. And, we contracted that, 2.5, 3 years ago. And when prices were still higher and solar hadn't dropped as much as it had. So, but otherwise today, I don't think it would compete with solar. So wind's not going to be there. And these repowering, leaning juniper, that's not going to happen anymore either, just because the production tax credit, even for repowers, is sunsetted as well. So the thought of, what Gilliam County has going for it and is because it has such a great wind resource on it. But without those incentives, it just doesn't compete. And so I don't think you're going to see a lot of new wind project development or repowering in the county anytime soon. That's just looking ahead right now, unless there's some project that already has its locked in its production tax credit that I don't know about that's in the county that's going to go there. And believe me, it's my job to know what my competition is, and I don't, but that's not that I don't know everything. But anyway, solar is going to have a monopoly. And here's the point. There is very few low barriers to solar. You need flat ground and a point of interconnect, and need to be on the east side of the Cascades. That doesn't bar and preclude a whole lot of projects or project areas. So you can go about anywhere and get the same solar resource as long as you have flat ground. And the whole thing is finding easily constructible ground, like we did for Montague Solar, to make sure it becomes competitive with other solar projects. But it really is a race to the bottom as far as pricing. If you want to attract solar to the county, I'd establish a red zone and attract it so you're at least you're on the same par as these other counties that have them, because the barriers to building the solar project are not like wind. Wind, you have to be where the wind blows. That's not the case with solar. So if you want to be in part of the competitive race to attract solar to the county, you know, that's, I mean, you need to do what you can do to do it. Otherwise, they will go, developers will go to a different location where they can put together the most competitive project. And I honestly, if you don't establish the red zone, you're actually sending the wrong message to the industry. So, and my last question to the commissioners is, if you've given the same level of incentive to all the wind projects before, why would you do it for these projects or other projects now and establish a red zone, other than you think you've already got this project and that going forward? I mean, but even at that for me is really the crux of the matter, to be honest, is that incentives are meant to encourage people to do things that they're not otherwise doing. And so I keep struggling with this, because this is not like we just came up with this project 6 months ago. I mean, you guys had this permitted for 10 years. You've gone through a lengthy, expensive FSEC permitting process. The landowner, you've got that. You've got the buyer already. We just passed the aggregate thing, so you've got rock. We did the Omega Morgan stuff, so you're landing, you know, all of your logistics stuff. I mean, this is what I continue to struggle with. It's not that I don't want you here contributing, but I want to make sure that if we're providing incentives, because yes, Gilliam County has something to gain as a community, not just Gilliam County local government, but we're also asking the taxing districts that provide quality of life, essential services here, to give up considerable revenue. And so for me, that cost benefit analysis has to work. It's not that I don't want you here, but just like with your company, where you have to make a cost benefit analysis on whether it makes sense to build here or not, I think us as the county commission have to do that cost benefit analysis to see if that makes sense. Because I mean, I want to make clear, I'm not concerned about the county's revenue in the first 5 years. I'm concerned about all of the taxing districts that provide schools, our schools, our health at the north end, the port district, all of those districts who will be. But if the project doesn't get built, Liz, like, yeah, if the project doesn't get built, you're not getting that revenue, like, at all. So I mean, it's like you're either, you know, you're not giving up anything if the project never gets built, right? So that's what it is. And I think there's a compelling case that the influx of spend during construction, I think we've illustrated, you know, it more, you know, maybe even if you took the most conservative approach to the local construction spend, you know, and we're not mitigating all of the loss of property tax abatement with the influx of construction, it's mostly being done. So then you're giving up, what you're giving up then is a revenue stream for 25, 30 years on property tax, or beyond that if we were to repower. And that's the guarantee, you know, it sounds like you're willing to gamble that, but I'm telling you that's what's on the line. So I just don't get it, you know, personally, why, you know, I'm telling you there's a risk, and maybe you think I'm not telling you the truth, but and that's, you know, that's your prerogative, but like I'm telling you there's a risk, and you can't whatever, you can believe me or not, but like, why not give the same incentive that you give in other projects for this one, and abate that risk for the long goals that you know would be guaranteed coming. So you're guaranteed, you know, moving forward, you're guaranteed to get it if you do approve the red zone, or you're going to gamble and maybe not get it. And maybe that's possible. But I also know that, like, I hear that the county has a surplus right now of, you know, maybe spending or budgeted funds or whatever, are doing better now. But regardless if there is or not, there is more tax revenue right now with the wind projects that haven't depleted or depreciated as much. So the need for tax revenue in the near term is probably, not as much as it will be in the latter years. And I don't know. I think.
And I get that. But the other thing I think that, again, to put out there is, based on what you told us during the presentation, if that 250 million valuation is the cap, no other no other solar company is going to invest in here, because Avangrid's going to eat up that entire cap with those two projects, are they not? So, I mean, it's going to be a one-time shot, right, for yours, but nobody coming behind you is going to benefit from that. Am I misunderstanding the cap? Because I thought the way that you described it was that cap was one.
Cap. Yeah, the cap is just an initial cap. So you can refresh. They just did it in Cook County too as well, because our Gala solar project moved forward along with 2 Invenergy projects at 50 megawatts, and they ate it up, and the county then refreshed the market value base back up to 250 million. So to continue to attract and provide that support for those projects is, just like I assumed here in Cook County, I assume that they're going to have a red zone there and there'll be an assessed value for me. But I'm also comparing, at another phase down in Cook County that is competing with those other 7 permitted projects that are there. So, it's whoever goes forward is the first come, first serve, and that's the way it goes. But the county has the tools and can apply as the county sponsor to refresh that initial. So it's not just one project. I mean, I just presented that Liz is you have a trigger, you have the control to how many projects get this incentive. The commission has that control, and that's why I presented that.
Additional questions, comments? One thing I did wonder is, if the county court went through and just said, yes, we'll do this, but we're not giving you year 4 and 5, would that still make it economically viable? Or are you telling us that in order for this to be economically viable, we would automatically have to do the extended abatement?
That was my question too. Is 3 years enough?
3 years is better than the pilot or like a SIP agreement for sure. But does it approve it? Does it get it all the way there that my company, that it's definitely a big step in the right direction. But again, you have the incentive, to, if you don't like 250,000 a year, maybe it's 300, maybe it's 350,000 for each year of 4 and 5. You have your tools, to put it in place. And if you can get comfortable with the 3-year, extended abate, 3-year, standard abatement for them and improving the red zone, then we could discuss the merits of a 4 and 5 at a later date and time when that comes in front of you. And you can make that decision at that point. But not in the red zone in place in the first place, you're not even giving yourself that flexibility to do it.
So commissioners, I think I need some feedback from you on where you're coming down and how you want to move forward.
Well, my feeling is I'd like to see us do something in a 3-year and then see what we can get done, what can happen. I still feel like we're having our feet held to the fire, but my feet are getting hot, so.
I mean, this is my concern as well, that, my understanding is the reason Wasco County has a red zone is that this was a similar tactic that was used with them, that at the 11th hour, Avangrid came in and threatened to pull the project. And so, I mean, I want to put that on the record that this is my concern.
That's not the case at all. Go talk to the commissioners. They're
I did.
Yeah.
That's who I heard from. Was that they were told that if they didn't do this for you, they were going to lose their project.
That was by me, Liz. I did not put that pressure on the county. That was not. I explained the benefits of that. And you guys, I'm not here to put your feet to the fire. I started this process with coffee with Liz. We started that in May of 2019 and introducing the red zone. So I don't mean to put you in a bind. I came to the county, a long time ago, and a year ago, Art Fish and I were there for the informational period, and that's fine. Your answer was no, we're not ready, not interested now, but and that still might be the answer today. But and to Tim's point, I'm not frustrated. This is business. This is the county. You live in the county, and you know what's best for the county, and you can make those decisions. And I just appreciate the opportunity to present the facts where they are and make the pitch for our project. But ultimately, that's the power that you've been elected to do and make that decision. And I fully support you. There's no hard feelings. This is business in the county, and you live in the county, and I don't. So I think this is prudent decision and deliberation, and I appreciate the thoughtfulness that goes into it. So,
Brian, I have a question.
Sure.
Okay, so if the county were to consider a 3-year, would year 4 and 5 not be negotiated at the beginning? Is that something that would be, determined later, or is that something that you would want to set up right from the get-go?
I mean, because time is of the essence, I'd probably come quickly with the application asking for the extended debatement period, but that's still, it would still be, it still goes in front of you guys to make the decision. So, but I don't think I think you could apply for them separately. I don't know. That's an Art Fish question, whether I could apply for the 3-year and then ask for the 4 and 5 later, but the application allows you to ask for the extended abatement, upfront. So, that would be probably that would be if there was a red zone established, I'd come and ask for, the additional extended, years 4 and 5, and that's up to you guys to decide.
Okay, so if no agreement was made on year 4 and 5, it would just be the taxes would begin.
It would just, if there was not a red zone established?
No, if
It's only 3 years.
If the
and if we hadn't come to an agreement
red zone and we meet the criteria, I think we get the red zone if we meet the requirements, to enter the Workforce Oregon employment, meet the employment standard, the minimum investment criteria. So, there's other criteria that we have to meet in order to get the 3-year standard abatement. But I'm not quite sure if there's a key discretional decision. Again, I tried to ask that question to Art Fish in preparation for this hearing, but I did not get that answer. So I just know with certainty for years 4 and 5, it takes the zone sponsors approval of that extended abatement period.
So Sherry, you had indicated that you are leaning towards looking at pursuing it, correct?
Yes.
With the idea that those extensions, the 4 and 5-year extensions, are case by case, as they come up.
Yes.
Leslie, how are you feeling? Same? Okay. So that would be a majority. So what we will need to do then is we will need to get in touch with Art Fish, because if I recall, when he was here a year ago, he said that the taxing districts have to have an opportunity to weigh in. So if I remember correctly, I thought he said there's a public hearing component that comes with that. So we would need to get clarity from the state on what the legal requirements are to be able to do that. So I can reach out to him and we can get clarity on that. Obviously, for those who are watching me at home, this is not a final decision because we actually have to go through that hearing process and have a legal document. So I'll need to get clarity from that and then probably get back in touch with you guys, commissioners, on setting up some meeting schedules to be able to do that.
Okay.
I think you, like the other step that I know that Wasco County and Sherman County took is getting the input from the different taxing districts. I mean, maybe that's a given for you in your process or whatever, but typically.
Yeah, and that, I got to be honest with you, Brian, the schedule, if you're looking at breaking ground in Q1, it's going to be a challenge to give you the clarity that, I mean, I don't know when your company is making this decision, but the public, because it's not just holding the public meetings, they have to be noticed ahead of time and all of those things. So when do you need to know? What is the decision date for your folks? Because that'll help us on setting up a schedule.
Yeah. If I had to guess, just knowing it's tougher to get on their agendas, and I know the next two meetings they can meet weekly, and it takes about 2 weeks of socializing before. So I think that at the earliest we would be in early December on their agenda to take the refreshed economics of the project or the challenged economics of the project forward. So I'd say early December. I mean, did you say your last county court hearing is December 2nd?
So that is likely the last for me, but the commissioners would still have a quorum and be able to move things forward.
Okay.
But for me, my doctors are telling me I should expect a baby in early December. So
generally good people to listen to.
Yeah, so thank you. Yeah, so in terms of timing, I mean, it just is a little tricky because we've got Thanksgiving next week as well. So here's what I will do. I will get in touch with Art Fish tomorrow morning, since we are already past 5 o'clock for today. So we'll see if we could even get in touch with him and get all of those components listed out of the steps that the county court would need to go through. And then we'll try to put together a schedule. And then commissioners, I'll have Teresa work with the two of you, because I'm not sure we would be able to get this through before December 2nd, realistically. That way you guys can kind of set a schedule to go through that process. We may get the public hearing done by then, but I'm not sure that legal counsel would have time to draft documents.
Yeah.
So.
Well, the resolution document, there's a template that's on the Business Oregon site. It's in the link in my presentation, so I can send that to you as well, or I'll send you the link to Business Oregon, but they make it pretty easy for the process. And again, if it was an enterprise zone, that's a really big, huge headache, but you can talk to Judge DeBoscus or Georgia over in Sherman County, or Tyler Stone in Wasco County, if you want some, how they handle it.
I have that sample up on my screen right now. So.
Okay. Yeah, it's fairly straightforward.
Yeah.
Yep.
Okay. So, and then we'll be in touch with you, Brian, once I have some clarity from Art on what all those steps look like. But if I recall, I thought he said we needed to have some sort of a public meeting with the taxing districts so that they had an opportunity to weigh in. So
yes, that's correct.
Yeah, that's correct. And then taxing districts need to weigh in, and then the resolution would need to be passed.
Okay. So I think I've got direction, and we will get working on this tomorrow morning, first thing.
Thank you.
Great. Thank you for your time. That's much more time than I ever thought we would spend on this today. And but I do appreciate the public input and the deliberations and thoughtful decision making.
Thanks, Brian. And then
much appreciated.
Okay. Thank you for your time and for being so patient on the early parts.
No problem. Thank you for hanging in there with my IT. I've got I don't have an IT guy here at the house, so looks like I need one here.
Thank you, Brian.
But thank you. Take care.
Thanks.
Bye-bye.
Bye.
And then let's see, are we back out to maybe, let me see if my view has changed here. There we go. Okay, so we still have some agenda items, ladies. Let's go into new business. Consider approval of intergovernmental agreement number 34389, production of coarse chip seal aggregate. And I'm just going to summarize this real quick because Dewey's on the line and so he can fill in any gaps. But basically, ODOT is requesting that our crusher produce some material at their Mayville quarry for their road repairs and maintenance on Highway 19 between Condon and Fossil. They would like specifically, you'll see sort of what they would like us to produce. The estimated amount that would be paid to the county is $168,000, and the county has entered into several similar agreements with ODOT in the past. So Dewey's recommendation is that legal counsel review the IGA, the county court approve it with ODOT, and Dewey was thinking we could fit that into next spring's work plan. Did I get that all, Dewey?
Yes, you did.
Anything I missed?
No, there will be some other materials that aren't listed on here. The reject material, they'll actually use that for shoulder rock, but it's just a byproduct of the chip seal rock.
Great. So commissioners, we have sort of two ways to approach this. This has not gone to legal counsel yet. And so I'm wondering if you guys have a comfort level in basically approving it pending legal counsel's review. And that would just allow us, in case she turns it around on December 3rd or something, I can just sign it then. That way we don't have to bring it back, if you guys are comfortable with that approach. And if so, there's some sample language in there. Or otherwise, she can approve it and I can bring it back.
I'm comfortable.
Yeah, we trust you.
Okay, good. So could I get a motion to approve that IGA pending review and edits by legal counsel?
I move to approve intergovernmental agreement number 34389 with Oregon Department of Transportation for production of coarse chip seal aggregate pending the review and edits of the legal counsel, county's legal counsel.
Second.
Okay, it's been moved and seconded that we approve intergovernmental agreement number 34389 with Oregon Department of Transportation for production of coarse chip seal aggregate pending the review and edits of the county's legal counsel. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, Dewey, I will get that off to legal counsel, and once she gets back to me, we'll get that signed for you.
Okay, we have plenty of time. It's just I have to coordinate the with the driller to get in there and get the drilling done prior to the crusher moving down.
Yeah, and usually with Christie, if it's a state contract, the state is not really keen on changing a lot of things. So usually we work with what they've given us. So hopefully that'll be a pretty quick review from her. 7.2 is consider approval of interlocal contract for cooperative purchasing of Carlson CP 100 commercial paver. And again, I'll just summarize this real quick and then turn it over to Dewey. But so the HGAC by interlocal contract for cooperative purchasing, it's another procurement alternative to our state bid and Sourcewell sort of options. Several of the large equipment manufacturers use that as their method to sell to government entities. And currently the paver that the Roadmaster is interested in purchasing is sold through that entity. So So anyway, and there's some information in here specifically about the paver that Dewey's interested in procuring, which would cost $230,211. If the purchase is approved, the funds would come from the general road asphalt line item, which has a balance of $1.5 million. If we decided to move forward with it, we'd first need to agree to the interlocal contract for cooperative purchasing. So that would be one motion, and then a motion to allow the purchase of the paver. Dewey, did I capture that?
Yes, you did. This is the same paver that we used when we did all the paving here 2 years ago prior to the COVID stuff. It's the same paver that Columbia County just purchased, and it's the paver that Mark over at Sherman County used this year to do his paving with, and he actually has his on order. I believe he's going through the same process I am right now to acquire the paver.
Great. Questions for Dewey, commissioners? Do we have motions?
I move to approve the HGAC by interlocal contract for cooperative purchasing as presented.
Second.
It's been moved and seconded that we approve the HGAC by interlocal contract for cooperative purchasing as presented. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. And then do we have a motion on the purchase of the paver?
I move to purchase a Carlson CP 100 commercial paver from Modern Machinery through the HGAC by contract in the amount of $230,211. The funds to come from the general road asphalt line item.
Second.
It's been moved and seconded that we purchase a Carlson CP 100 commercial paver from Modern Machinery through the HGAC by contract in the amount of $230,211. The funds to come from the general road asphalt line item. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay. Next one for Dewey is consider approval. Oops, sorry about that. Consider approval of purchase of 140A CAT grader. And again, I'll just summarize real quick. Road Department would like to replace the 1998 CAT motor grader, which has 12,300 hours on it. The Road Department runs 4 graders. They are in most years the most used machine. And Dewey can go into all those reasons why. But there are 2 bids in here for your consideration. There's only 2 because there's no other dealers that service Gilliam County. So I think that would be an acceptable reason to only have 2. We tried to get 3, but there isn't a third to be had. So Dewey, I don't know if you want to walk through the 2 different bids and maybe give your recommendation on which one you think is the best.
Okay, we've actually test run the Komatsu grader. It's a very good machine. The only problem we would have with that would be basically service. The CAT machines, everything we have is pretty much off the shelf. What we have now will match up with that machine. Our cutting edges, tires, everything. With the Komatsu blade, we would actually have to buy some spare parts to have on hand. And then Caterpillar actually has a service mechanic that lives here in Condon who works at Waste Management every day, but he does come and service us whenever needed. They're both very good machines. I just think right now, as far as serviceability and working with us, that the CAT machine is probably a better machine, better fit for us.
And it looks like with the rim and tire that you were going to have to add, it comes in a little bit less as well, doesn't it? I mean, not much, but
It's just a little bit. Yeah, the cap machine is just a little bit less money. Yes. And the warranties and everything they're almost identical. They have a fail-safe warranty, which means they take care of any issues we have for the first 5 years. The SOS oil sampling, they take care of, both of them do. Everything's hooked to the satellites now, so they can do automated repairs if needed to be, updates to the computers. Yeah, they're both very good machines. I just think CAT is a better fit for us.
Great. Any questions for Dewey on the two options, or
I don't have any.
do we have a motion?
I move to accept the bid to purchase the cat grader from Western States in the amount of $238,332.25. Those funds to come from the General Road Equipment Replacement Fund.
Second.
Line item.
It's
right?
been
No,
fund.
I'm starting to get rummy. Is it fund or is it line item?
It's fund.
Okay, fund.
So it's been moved and seconded to accept the bid to purchase the cat grader from Western States in the amount of $238,332.25. The funds to come from the General Road Equipment Replacement Fund. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. 7.4, one more for Dewey, which is consider approval of purchase of used reconditioned crusher screen and new wrap wrangler. So the road department would like to replace the existing 5x16 3 deck screen. I'm sure I'm saying that wrong, with a reconditioned 6x20 3 deck screen. The new screen will up production by close to 20%. And then the old screen can then be used with a new wrap wrangler to process recycled asphalt that the road department's been stockpiling to produce their cold mix for paving. And that will allow them to process that recycled asphalt without having to move the entire crusher, which I had no idea, Dewey, that it takes you 2 weeks to move the entire crusher. So that's interesting. And that they're estimating that they can set up the new wrap wrangler in just a matter of a few hours. So currently there are 2 equipment dealers in the Northwest that offer the reconditioned screened equipment. Freight costs outside of the Northwest would make that cost prohibitive. So again, I think we're looking at, this is why we don't have 3 quotes for that. Because of our remote location. And then the other thing is the wrap wrangler appears to be the only small asphalt recycler machine on the market. So Dewey made several calls to contractors that are using it. They got favorable reviews. There's some costs in your briefing, and the funds would come from the General Road Equipment Replacement Fund. Dewey, did I catch everything? I'm sure I'm really skipping over some important stuff.
Hey, it's getting late in the evening, and I know you gals are tired. Yes, you got everything. The screen, by taking the old screen that the crusher's using now and integrating it in with the wrap wrangler, we will be able to just set up and make our stuff rather than having to pick up the entire crusher and move it and set it up. Our rock crusher is valued about $3 million, where this whole outfit will only be, if we have 50 to 60,000 in it, I'll be surprised by the time we set it up on a trailer with everything. We have all the components. It's just a matter of putting them together to make the machine that we need. And that'll allow us to just process the wrap right into our pug mill, haul it right out, put it right in our brand new paver, and start paving roads. So should be able to get right to work.
Good deal.
Great. Questions for Dewey on these?
No.
No.
So we'd be looking at two separate motions, one for the reconditioned screen and then one for the wrap wrangler.
Is it my turn? I move to accept the bid from AC Tech for used 6x23 reconditioned Cedar Rapids screens in the amount of $114,000. Funds to come from the General Road Equipment Replacement Fund.
Second.
It's been moved and seconded that we accept the bid from AC Tech for used 6x23 reconditioned Cedar Rapids screen in the amount of $114,000. The funds to come from the General Road Equipment Replacement Fund. Is there a further discussion?
No.
All those in favor?
Aye.
Aye. Any opposed? Motion carries. And then is there a motion on the wrap wrangler?
Oh, yes, I could do that too. I move to accept the bid from the ACE Group for a wrap wrangler 50 horsepower in the amount of $31,650. Funds to come from the General Road Equipment Replacement Fund.
Second.
It's been moved and seconded that we accept the bid from the ACE Group for a wrap wrangler 50 horsepower in the amount of $31,650. Funds to come from the General Road Equipment Replacement Fund. Is there further discussion?
Yes, that the price that there was a mix up. Well, from the time I got the bids and stuff, it's $33,850 for the wrap wrangler.
30. Say that again, Dewey.
$33,850. I amend my motion to $3,850.
Second that.
Okay.
Okay.
So,
Thank you very much.
so the amended motion reads, I move to accept the bid from the ACE Group for the wrap wrangler 50 horsepower in the amount of $33,850. The funds to come from the General Road Equipment Replacement Fund. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay, we're in the
Thank you
home
very
stretch.
much.
Yeah.
Thanks, Dewey.
Bye, Dewey.
Bye.
Thanks for sticking with us for 4.5 hours.
Yeah, way to go.
So 7.5 is consider award of fiscal year 2020-2021 fall capital investment grant. Sorry again. I keep getting the notices that we've got a call with the governor's office in 5 minutes. So
2 minutes. 2 minutes.
So we'll keep going though. They can wait for us for 2 minutes.
Okay.
Okay. So the grant review team met and reviewed the grants. We had 4 applications. Those are in your packet, their recommendations. And so since that time, actually earlier today, we got an email from Catherine saying that it does not look like ODOT is going to fund their Safe Routes to Schools grant. So I just wanted to put that on the record, that it's unlikely that they're going to receive those matching funds. And I know that that was a condition that the grant review committee had recommended that we impose. So I'm wondering if we want to just take this one at a time and just start with the city's first one, which is the housing project at the baseball field. The city requested $175,000, and this is going to help with basically getting those proposed 6 lots with the amenities, the sewer and water. And I think as well with some planning and surveying to get everything plotted. So wanted to see feedback from folks. The grant review committee's recommendation was to fund it.
And I agree with that.
I do too.
It's a good project. Want to continue to help them move that forward. So I move to approve the Gilliam County Capital Grant for City of Condon for $175,000 for their housing project.
Second.
Okay, it's been moved and seconded that we award a fiscal year 2020-2021 capital investment grant to the city of Condon in the amount of up to $175,000 for their housing project. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion carries. Can I assume in that one that you guys are okay with me moving forward with putting together and executing grant agreements? Okay, just wanted to make sure that I wasn't overstepping. So the second one, again, this was from the city. This has to do with their safe routes to schools. Basically, they applied for a grant to help install sidewalks near the proposed grade school in Condon, the new one. It's not proposed, it's being built next year. And again, Catherine told us today that it is unlikely. She did not say they definitely are out, but she thought it was very unlikely that it would be funded. So I don't know if we want to not fund this one or just stick a condition.
Can we look at it again if
Yeah, can we just put it on hold and see what happens? Or ask, maybe they just need to come back in the spring. Do we have capital grants?
Yeah. Yeah, and Catherine thought that if they're rejected for it, they can't apply again until next summer, and so it would be like next fall before they would probably need matching funds. So I think that would be okay, and if something changes, we could always pull it back and put it back on the agenda.
The school project is not for 2 more years completion, so, okay.
Yeah. Okay, so what I will do is I will just put that in a holding pattern. If something changes and ODOT surprises us, we'll put it back on the agenda, but otherwise we'll plan on them resubmitting a grant once they get a favorable answer from ODOT.
Okay.
So the third project is from Gilliam County Historical Society. The request is for $60,695. This is for the next phase in their building project. If you recall, we gave them a special projects grant to sort of get things going, and they've raised quite a bit of other money outside of that since then. And so they are coming back looking to do basically phase 2. The grant review committee recommended a scaled down version of the project, asked them to try again this spring, perhaps talk with some local excavators to donate site prep, entertain the idea of a gravel floor versus concrete. And so their recommendation was not to fund it. And so I'm looking for feedback from the commissioners on this one.
I'm at a loss for words because I'm not sure why they.
Who was on the committee again?
Do not fund.
Same people?
So it was, I think, Teresa, Nathan, and Kelly, did you sit in on that one as well? Yes, Teresa is telling me through the door.
I don't agree with the gravel floor. I think that in order for it to be a long-term thing, they need a cement floor, but yeah, I don't know.
Remind me how much was the last grant? That might be
20,000,
but I don't remember.
Yeah,
so
and that was just for preliminary stuff too.
Yeah, I mean, for me, I feel comfortable funding it. Honestly, I wish they would have just come to the capital investment grant the first time and just done one grant for the whole project. I think that would have saved them some time and some heartache. I think they were trying to shoestring it along. And my understanding on the floor is that that's a ADA accessibility issue that their project manager ran into when he was working with them on that. So
So, yeah.
See, I would like to see us fund it.
Yeah,
Okay.
I really appreciate the committee. I don't want to say, but I'm not sure why we wouldn't fund it.
Okay. Do we have a motion?
Your turn.
Yes. Let me see if I can do it. I move to award the fiscal year 2021 capital investment grant to the Gilliam County Historical Society in the amount of $60,695 with conditions imposed as discussed and pending a fully executed grant agreement, and authorizing the county judge to prepare and execute such grant agreements. It's getting late.
She's exercising right now, but that was not a bad idea.
Not a lot.
Second.
Is there a second? You second? Okay. So it's been moved and seconded to award a fiscal year 2020-2021 capital investment grant to the Gilliam County Historical Society in the amount of $60,695 with conditions imposed as discussed and pending a fully executed grant agreement. The county judge authorized to prepare and execute the grant agreement, or exercise as the case may be. Is there further discussion?
No.
All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. Okay, last one. This one comes from the Arlington School District. The request is for $34,074. And they are looking to put in some community reader boards downtown to help create a positive infrastructure within the community. So the boards can be utilized to advertise businesses, post school announcements, and just communicate daily happenings throughout Arlington. And the grant committee felt that this would also improve the livability and quality of life in the sense of providing attractive reader boards downtown. It has good community support. Arlington schools have been working on finalizing some contributions from the community. And so the grant review committee is recommending that we fund it at $28,000 as opposed to the $34,000. That is based on us not funding the maintenance. So funding the actual reader boards, but not the maintenance, I think is the recommendation. Thoughts or questions on that one?
I'm excited about this project. It's one of the things I've wanted to see since that they quit using the one that's by the city hall a long time ago. I think it keeps us informed of what's going on, and I'm supporting this project.
Yeah.
I think it's awesome. Yeah, I support it too.
Yeah.
Do we have a motion?
Better than the one at the school that they have to use the little thingy to change the letters.
Exactly.
I will make
I
move to award a fiscal year 2020-2021 capital investment grant to Arlington School District in the amount of $28,000 with the conditions imposed as discussed and pending a fully executed grant agreement. The county judge is authorized to prepare and execute the grant agreement.
Second.
It's been moved and seconded that we award a fiscal year 2020-2021 capital investment grant to the Arlington School District in the amount of $28,000 with conditions imposed as discussed and pending a fully executed grant agreement. The county judge is authorized to prepare and execute the grant agreement. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. All right, last one for now is 7.6, which is consider approval of the 2020-2021 County Court Board and Committee appointments. So this is obviously looking forward to January, and to Steve Schaefer's point earlier, there's maybe some questions on why this is coming up when it is. My thought process was I want to make sure that that because I'll be on maternity leave, that we are not not represented on committees and boards in early January. So I did share this with Commissioner-elect Shannon, who I see is still on there. And Pat, were you okay with the committee assignments? Maybe. I'll give you a second to unmute.
Unmute. Clickety click. You're frozen. Frozen.
He's just trying to find it, I think.
He's frozen.
There you go. Oh, you were there. There you go.
That took a minute.
Now he's
Yeah,
back.
I'm fine with him. I know you had mentioned that you had some. If I was interested in, we can have that conversation later. But yeah, I'm fine with those.
Okay,
Did
great.
you
And
check-
Sherry, you're okay with?
Did you check and
Oh,
make
go
sure?
ahead,
that-
Pat.
Did you check and make sure you didn't think there's any conflict of interest issues over North Central Health?
I think you will be okay, but we can still check. I think I'm technically the alternate on that. So if for some reason it comes back that that's not going to work, we can always reconfigure that. Or if we want to wait, and have me go to the initial meetings while we sort that out with the Ethics Commission.
I don't think.
But my guess is you would just have to recuse yourself anytime fees come up related to restaurant inspections, probably at the public health side is my guess.
It's not often either. I mean, it maybe gets discussed once a year from my experience so far.
Okay.
Great. And Sherry, you were okay with yours?
Yeah, I just had an addition because I'm on the ECAN Extension Citizens Advisory Committee. So we just need
Oh,
to
yeah.
That's right.
Extension Citizens Advisory. Okay. So could I get a motion to approve those
Yeah, I move to
with
approve
the
2021-2022 County Court Member Committee assignments as amended.
Second.
It's been moved and seconded that we approve the 2021-2022 County Court Member Committee assignments as amended. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? The motion carries. The governor's office is really
I know, and I want to get on there too.
I know, we're almost there. Okay, so announcements and next meeting. Next meeting is going to be December 2nd, 2020, unless, well, I can't imagine that we're going to have the red zone stuff put together before then. If something happens on the red zone, I'll let you know, but I'm not sure that we would be able to do all the public notices in time to be able to do that prior to the 2nd. So that will be the next meeting. Any other announcements or things that you wanted to raise?
I had some.
Yeah, you did.
I think they can maybe wait till December 2nd.
Okay.
And I'm just concerned about your blood sugar. You need to get something before you get on the call.
Okay, I will do that. Okay, so nothing more for the good of the order, it looks like.
Yep.
So it is 5:41, and I will go ahead and adjourn the meeting.